Hey, praise the Lord. I'd like to
Yes.
mention item number 12, Your Lordship.
Over volume.
Item number 12, Your Lordship. Item number 12, Your Lordship. Mr. Lordship, we have heard that the appellant, the respondent has expired, Your Lordship. We need some instruction or Your Lordship, the report may be called from the concerned police station is regarding the existence, Your Lordship. I'm for the respondent, Your Lordship. The state.
But you obtain instruction whether the respondent
Your
suffered
Lordship, we
demise
have-
or not. We will
Your
grant
Lordship,
you
we
1
have-
week time.
No, Your Lordship, we have sent a letter, Your Lordship. The letter has been written unserved, Your Lordship.
Report has come.
No, Your Lordship, we have sent a letter to him, Your Lordship, but the letter has come unserved, Your Lordship. That's why, Your Lordship, we presume that he has
So
expired.
you inquire about it. We'll see.
2 weeks
you-
time after Bihu vacation, Your Lordship.
Okay. On the pair being made by Ms. Nazdin, learned counsel for the appellant,
No, Your Lordship, of a respondent, Your Lordship. The state
The
is the
respondent.
appellant
appearing on behalf of
here. Jed Alam, Your Lordship.
that alum, learned counsel for the respondent. This is the matter after Bihu vacation.
Obliged.
Yes.
May I please, Lordship, I have paid for listings to I, my lord. One is for withdrawal the deposited amount and another is for compromise, my lord. MSc appeal, my lord.
When do you want?
My lord, 1st April.
First April, fourth April.
Oblige.
May I please, your Lordship. Item number 21 and 22, Lordship. I'm on behalf of I Hawk, Lordship. He is not well, so he could not come. We have already taken consent of the other side, Lordship. The matter may come after vacation, Lordship. Item 21 and 22, Lordship.
You are for the appellant.
First item, I am for the respondent, I Hawk, and second, Lordship, with the appellant, Lordship.
Okay. Mr. Sharma, learned counsel appearing on behalf of Mr. I Hope, learned counsel for the respondent in MSc appeal number 084 of 2022. With consent from the other side, press for listing the matter after
Vacation, Lordship.
vacation.
21 and 22, Lordship.
In reverse in the next line. MSc appeal number 290 of 2020. Yes.
May I please, Your Lordship, I beg to
Obliged,
mention for listing an RSA
When?
on 4th of April. Not
In
4th,
which column?
okay.
In which column?
Under which category? Hearing orders.
Orders.
Order.
May I please, Your Lordship? Lordship, I beg to mention item number 14, Lordship. Here in this matter, Lordship, I have instruction that the sole appellant has expired, Lordship. So I need to file an application for substitution of his legal heirs, Lordship.
Okay. Your good name, please.
S. Paul, on behalf of A. Bhattacharya, Lordship.
Mr. S. Paul.
Yes, Lordship.
Learned counsel appearing on behalf of Mr. A. Bhattacharya, learned counsel for the appellant submits that as per his instruction, the sole appellant suffered demise. And he may be granted some time to take necessary step for improvement of legal heirs of the appellant.
So,
You inform the other side.
Lordship, I have informed, but who is appearing for the other side, I'm not aware. Because in the cause list, Lordship, there is no name. of
One
the-
is K. Talukdar.
K. Talukdar is our advocate only, Lordship. It
Your
has been wrongly listed, Lordship. I'm not aware, Lordship. Actually, who is appearing for the other side?
Dia tuh guys, aja tuh aku mau step to the way. Di pun pak ada tadi uji lah. Compare a lot.
Much obliged.
Yes.
With regard to item number 16, your lordship, today we have some difficulty. We have taken content from the other side. We have supplied the adjournment request yesterday.
You are for appellant or
Appellant, AM doctor.
I'm for the respondent,
A.
Lordship.
AM doctor, your lordship.
Mr. M. Dr. Learned counsel for the appellant with consent from the other side, press for listening the matter. When?
6th of May, it's a Tuesday, your lordship.
This is of 2013.
13, yes.
Why 6th of May?
Then your lordship, 24th of April, your lordship. Because 24th April, 24th.
Yes. Okay.
month.
May I please, Your Lordship? Lordship, I beg to mention for listing of a matter, Lordship.
When?
On first week of April, Lordship.
On
Take a date from him.
10th April,
Yes,
Please, Your Lordship.
10th
The
April.
consent of the other side, I beg to mention item number 15, my lord, this 2011 matter. The issue involved in this case is pending before the Honorable Apex Court, my lord. Just have to take the instruction whether that matter has been disposed of or not.
item number 15.
15, my lord. So can it be taken up in April last, my lord?
Last,
Last part of April? My lord.
but did you inform the other side?
Yes, yes, I will inform, my lord.
Okay, Mr. Your good name, please?
B. Sharma,
B.
B. Sharma.
B. Sharma, learned counsel for the appellant
Appellants.
with consent from the other side, press for listing the matter in the last part of April, so as to enable him to obtain the instruction as regard the pendency of pendency of one SLP or
SLP, my lord, on the same issue, my lord.
on the same issue before the Honorable Supreme Court of India. Where is allowed, recusal is the matter in the last part of April.
Much.
May I please, your lordship? Lordship, I beg to mention for listing lordship.
Fine.
Any date, lordship.
Take
On
that from
23rd April, may I please, Your Lordship, for item number 9 and 10, actually, we are on the respondent side. We have filed an affidavit in operation yesterday. So kindly the affidavit in operation will be tagged today, my lord, with the records. Sleep.
May please, your lordship,
Yes.
lordship, in regard to item number 1,
item number,
1,
yes,
I'm praying for accommodation for the dear lordship. I'm not keeping well. I have informed the other side, he's there also.
Hmm.
Can the matter come up on 22nd of April, just after the reopening?
27th of April,
22nd, lordship. It's a
22nd.
Tuesday hearing day.
Okay. With consent from the other side, Ms. Idas, learned counsel for the appellant, press for listing the matter on 22nd of April. There.
Deeply obliged.
May I please, Your Lordship? My prayer is for listing of CRP IO, my lordship.
When?
7th of April.
7th of April.
May please, Your Lordship. Lordship, I'm praying for listing of IA for orders, Lordship. 2nd of April, Wednesday.
2nd April. Items for admission, parted matter, item 2.
In fact, Lordship heard this matter at length the other day, and my
Yes.
learned friend wanted to produce a judgment.
Mm.
Well, I find that the judgment is of, my lord, has got no connection in this case.
Mm.
My lord, I'll distinguish the judgment, my lord. That judgment was on a 1981 circular, which was non-existent, first of all. Secondly, my lord, that circular was with regard to people who were claiming directly upgradation of scale. That has got nothing to do with the 1883 notification. It was of 81 notification, which was in fact non-existent. It is supposed to be a fake notification. That is what the case is all about. Secondly, our case is not based on any notification. Our case is based on rules, 2003 rules. And the notification of 83, which the department is relying upon, that is not what we have relied upon. They have denied our claim, saying that 1983 notification has been withdrawn in 2011. Our case is as per 2003 rules, and that is our specific pleadings are to that effect. In paragraph 14, we have very specifically pleaded that as per section 3 proviso, page 6 of my writ petition.
Paragraph number?
14. Page 6, last
Yes,
paragraph.
sir. You have already pointed out.
Yes, that I pointed out. And secondly, we have also pointed out that for all practical purposes, next paragraph, all practical purposes, I have been rendering services as an Arabic teacher. Now, these two paragraphs, they have not denied in their affidavit. Their affidavit doesn't deal with this paragraph at all. They simply come and say that there is an 83 notification. There was an 83 notification. That notification has been withdrawn in 2011. That is another story of the matter because it was withdrawn in 2011, not before my amalgamation took place. So therefore, whether that is effective also, that is another issue. But I am not on that. I am basically on the rules. And the rules are very clear that only when the post is vacant, post falls vacant on the retirement or death or whatever,
of the incumbent who is holding that post, graduate post. If the person is having graduate qualification, just like I'm having, this person has to be upgraded. It is not a case where the moment he enters the elementary, so the highest high school, he'll be entitled to the scale. No, only if a vacancy arises. Now, if I had joined, suppose I'm an Arabic teacher.
Yes.
Now, I just give a hypothetical example. Suppose since I'm an Arabic teacher. Now, for example, if a vacancy arose in say Assamese or Hindi language in the graduate scale, I couldn't have claimed benefit because my post has not that post has not fallen vacant for me. Here is a case where the incumbent who was a graduate incumbent was holding the post. He had retired in 2011, and pursuant to that, I filed this representation saying that since he has been given this, he has retired, the post has fallen vacant. Therefore, my prayer is that I should be upgraded against the said post of Javed Ali, who retired on 30/11/2011. That is my specific case. I am not claiming it right from my entry into the high school amalgamation in 2006. I'm only claiming for 2011 when the post fell vacant in terms of the proviso, Rule 3 proviso. True. Proviso says that it is true that the proviso says there will be no fresh recruitment. I am not a fresh recruitee, Your Lordship. I have been amalgamated, and the amalgamation order itself reflects that the post has been absorbed. And in fact, the impugn order also at page 25 reveals that the post in which I was working in the elementary school, that has been absorbed in the high school. And it is not a case of fresh recruitment, therefore. Therefore, I am squarely covered with the proviso to Rule 3 of the Assam Secondary Education Provincialization Rules 2003, which says that there shall be no fresh recruitment to the cadre. I don't fall into that category. I'm not seeking any fresh recruitment. It says that provided that there will be no further recruitment to the cadre of junior teacher, junior classical teacher, junior Hindi teacher, senior classical teacher, and all existing posts shall stand upgraded as a graduate teacher or Hindi teacher having bachelor degree from any recognized university or classical teacher, Sanskrit, Arabic, I'm an Arabic teacher, Assamese language teacher, as the case may be, from the date such posts become vacant, either as a measure result of retirement of existing incumbent or otherwise. So when this Javed Ali retired, my claim is that from that date, under this proviso, I'm entitled to this benefit. And it is only
Yes.
it was not my case that I am covered by this I am seeking this benefit within the 83 notification, from the 83 notification. This notification they have brought on record in the impugn order at page 25, Annexure 7, to reject my claim, saying that this notification is in withdrawn. That too in 2011. Not when I was amalgamated or when this vacancy arose, number one. Number two, this impugn order does not have any whisper, does not even deal with Rule 3 of the Provincialization Rules 2003. It's totally silent. And on 16 December 2014, when this impugn order was passed, this 2003 rules were still existing. 2018 rules came much later. I've given one judgment, other day I've placed one judgment with your lordship, that it is in prospective effect. It does not have retrospective effect. It's very clear. It was to take effect from the date of gazette notification. 2018 rules, which has repealed this 2003 rules, that came in much later. And when this impugn order was issued on 16 December 2014, the 2003 rules was very much existing. But this notification, this impugn order does not deal with that issue at all, does not even discuss Rule 3.
Impugn order is updated
16 December 2014, Annexure 7, Your Lordship.
16.
December 2014.
Yes.
So they have proceeded on a wrong premises altogether. They've ignored the most relevant consideration, the rules.
Okay.
And in their affidavit, they have not even bothered to controvert what I've stated as per the, so that I'm entitled as per the rules, and that I'm working as an assistant teacher, an Arabic teacher, and discharging duties in the higher school classes. So therefore, in my humble submission, as per this Rule 3 proviso, I'm seeking my benefit. I'm entitled to the benefits because this is what I'm relying upon. All this reliance on these notifications, etc., which the department is trying to circumvent the rule, are not applicable at all. The rules cannot be superseded by these notifications. When 2003 rules came into force, that is what will hold the field. And these are the rules framed under Section 3, Article 309 of the Constitution of India. So they have got statutory force. So this cannot over notifications cannot suppress, surpass, or override the 2003 rules. So that is my humble submission.
Okay. Yes, Mr. Karunia.
Yes, ma'am. As it is the judgment I have referred to, the case of Punapur Bodole. This judgment deals with the issue that if a person entered into a service, the scale of intermediate scale of pay, he cannot claim for graduate scale of pay. The petitioner submitted a representation at Annexure 5, page 21. His prayer was to prayer for upgrading from intermediate scale pay to graduate scale of pay. So in this judgment, this honorable court particularly deals with the issue whether if a person entered into service in an intermediate scale of pay, can he claim for graduate scale of pay on his subject to his fulfillment of qualification of graduate, my lord. And this issue was decided negate in affirmative, my lord, saying that, my lord, if a person when otherwise also the petitioners having not been appointed as assistant teachers in graduate scale of pay, they cannot claim the same scale unless they are appointed in the same scale of pay. So the basic claim of the petitioner in this case to upgrade his from intermediate scale to graduate scale of pay. But his entry to the service is in the intermediate scale of pay. So, my lord, as per ratio laid down in this case, my lord, he cannot claim for graduate scale of pay. That is my humble submission. And as regards the proviso to Rule 3, my lord, this is upgradation is not a matter of right, my lord. Here in proviso, provided that there shall be no fresh recruitment to the cadres of junior teachers, junior classical teachers, junior Hindi teachers, senior classical teachers, and all such existing posts shall still upgraded as graduate teachers or Hindi teachers having bachelor's degree from any recruitment university or classical teachers so and so, as the case may be, from the date of such post became vacant, either as a result of retirement or existing incumbent or otherwise. So if it is all vacant, my lord, then that post will be upgraded, my lord. It doesn't necessarily mean that the person holding the post of assistant teachers in intermediate scale, he has to be upgraded to a post of graduate teachers, my lord. That post has to be upgraded from junior teachers to graduate teachers, and then that can be filled up by the direct recruitment, my lord. There is no necessity to upgrade the person who is below the rank of assistant teacher in intermediate scale of pay to the post of graduate scale of pay. That is not the mandate of the law. So this is my humble submission.
Heard Mr. M. Dotto, learned counsel for the appeal.
Just for one submission, so far as this judgment is concerned, it did not deal with 2003 rule at all. That's
2000?
3 rules was not at all dealt with by this judgment by Malan and Pillai. Another distinguishing point.
That also heard Mr. Katonier, argument concluded. Judgment is there.
Apply, Your Lordship.
Motion item 25. Item 25. Item 26, 25.
Hello. I have filed your IA lordship, that is 905 probably lordship. My humble prayer before this honorable court. The order have been, the annexer 6 your lordship. (903). I had filed on IS your lordship. And also probably your lordship 57 is the page where we have also challenged the contention of the day of the delay of the order. Page 57 of that impugn order, your lordship. Passed by the district judge, your lordship. In Miss KJ. 1 of 2021.
Pardon?
Page 57, your lordship, of my instant petition, your lordship. On the paragraph 6. The cause of delay have been also been issued as well as raised before the trial court. On page 7, that has been reflected in paragraph 6, your lordship.
At this instance, so we cannot consider that aspect.
I oblige lordship. Whatever this honorable court permits to give in any direction, I will take the oblige. All my career is concerned, your otherwise, lordship.
Heard Mr. Gogoi, learned counsel for the applicant. This interlocutory application under section 151 of the Code of Civil Procedure is prepared by the applicant. For correction. In the cost item of the CRP IO number 107 of 2025. Mr. Gogoi submits that in the aforementioned, no, in the cost title of the aforementioned CRP, the impugn order is mentioned as dated 22nd of December 2023, but in fact, the same ought to have been 16/12/2023. And as such, he may be permitted to make necessary correction in the aforementioned post title. Aforementioned date in the post title. There is accordingly allowed. Mr. Gogo shall furnish corrected amended post title before this court within 1 week from today. The IA, no, in the main petition, you take down. Heard Mr. Gogoi, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India is preferred by the petitioner challenging the order dated 31/5/2024 passed by the learned district judge under Order 21 Rule 11 of the Code of Civil Procedure.
Ninety-seven is the page, your lordship, effective order. 1/3/2025, lordship, that order.
Which order you were challenging in this petition?
All the other subsequent orders, thereafter the latest operative order is 1/3/2025, page 97, your lordship, annex 23. Whereby the date has been fixed on 29/3.
And also the order dated 22nd December 2024 in Mizje case number 1 of 2021, and the order dated 1/3/2025 Hospital Learned District Judge. In title execution case number 1 of 2024. Is to be noted here that by impugn order dated 1/3/2025. Impugn order dated 31/5/2024. The learned district judge is directed to register one title execution case. Upon the Miss J case number 1 of 2021 arising out of titles of certificate D number 15 of 2010. Then where is the second order that 22nd, 12, 2023? The next sir.
Ninety-one, your lordship. Page 91, annexure 17.
And the order date and by the order dated 27, 11, 22nd, 11, 2024, the learned district judge has directed the petitioner to deposit remaining amount of permanent element along with monthly maintenance amount on next step. And by the order dated, impugn order dated 1/3/2025, the learned district judge Port Lochinpur has directed the petitioner hearing. Uh, the learned district judge has called for the salary slip of the petitioner from the principal P. Puria College, Port Lochinpur. And also issue notice to the petitioner to show cause as to why his salary should not be attached for realization of the decretal amount as per order 21 of the CPC. And further directed the respondent hearing to file land document in respect of the property, that's serial number 2 and 3. And the copy of registration certificate of serial number 4 property mentioned by her in the list of movable and immovable property of the judgment debtor. And fix the matter on 29/3/2025 for submission of salary slip by the principal of B. Puria College, payment by ZD, judgment on the payment by ZD, that is the petitioner, and report on the writ of attachment issue against ZD. Mr. Gogoi, learned counsel for the petitioner submits that on 1/8/2025, the petitioner would not remain present before the learned
Supervisor of high
Court
secondary.
of the district judge, not looking for, as he was busy in conducting
SLC and high secondary examination.
ACES and ACES and high secondary examination at
In college. In Bipur college,
in his college,
in this college.
And that the petitioner is ready to make payment of the amount and payment of the entire amount, and he has been applied for loan to the bank, and as soon as he will receive the amount, he will complete the he will make payment of the entire amount of element. And therefore, Mr. Gogoi submits that the impugn order dated 1/3/2025 may be stayed. till disposal of this present revision petition. Where having heard the submission of Mr. Gogoi, learned counsel for the petitioner. It is provided that notice be issued to the respondent, returnable in 4 weeks, that they take it by lesser force with KD and also the usual process. What is the amount you have paid till date?
3,70,000, Your Lordship.
Is there any documentary proof in this petition?
I had mentioned, Your Lordship. It is there in the order sheets, reflects on the order sheets.
Which order?
All the order sheets in the. It can be calculated 3,50,000 after filing, he has paid 20,000, then 3,70,000, Your Lordship. In all the order sheets, it's been reflected, Your Lordship. Annexure 9,
Mr. Gogoi further submits that the petitioner was directed by the learned district judge Lakhimpur to make payment of rupees 10 lakhs as permanent alimony within a period of 5 months in 5 installments. By judgment and order dated 22/12/2023. And thereafter, the petitioner had paid a sum of rupees 3,75,000. Whereas taking note of the submission of learned counsel for the petitioner and also considering the facts and circumstances of the record. The impugn order dated 1/3/2025 stands state. Subject to payment of a sum of rupees you pay 5 lakhs before the trial court. Subject to payment of a sum of rupees 5 lakhs being the permanent alimony before the court of learned district judge Lakhimpur within a period of 1 week from today.
2 weeks, Your Lordship.
No,
My
no.
father was
Within
also,
a period of 1 week. 10 days from today.
Lordship.
This is the matter after 4 weeks.
I'm deeply obliged, Lordship.
26.
May it please your lordship. The petitioner is the defendant number 1 before the trial court, lordship. The suit was for right title interest and confirmation of possession. We have filed our written statement stating that defendant number 1 purchased the suit land by the registered sale deed, lordship. And during trial, lordship, the defendant adduced 3 evidence, 3 DWs, all were cross-examined, lordship. And defendant number 4 was summoned. He appeared on 7/3, lordship. Page 34, your lordship will find the petition filed on 7/3. Page 34, annexure 4, lordship. On 7/3, he appeared, and thereafter, after due to his sudden illness, lordship, he left the court. So we filed an application that the above suit is fixed today for defendant's witness. Defendant's witness though came to the court and filed Hajira after putting his signature, but due to sudden illness, he returned to his home at this juncture. Another date may be fixed for cross of DW after allowing an adjournment today. So lordship, this petition was allowed, page 36. And lordship, immediately after 5 days, next date was fixed on 12/3. On 12/3 only we took 1 adjournment, lordship. And as per order 17 rule 1, lordship, At least 3 adjournments I am entitled for, but Lordship, I am not seeking any adjournment only because on 7
So
March he
is
was.
it your case, since the date of fixing for the evidence of the defendant, you have not availed three dates?
No, Lordship, that DW3 Lordship already completed. DW3 was cross-examined. He was partly
No,
cross-examined
you
on 3
tell me
different dates.
on 12/3/2025,
Lordship,
the witness remain absent without furnishing any medical document.
on 12/3 Lordship.
12/3.
5/3 already,
Yes.
7/3 we have already submitted a petition that the witness came to court.
No,
And
on
thereafter-
12/3/2025, you have filed another petition.
Yes, Lordship, that is an.
On account of illness, the witness could not remain present in the court.
Yes, Lordship.
Where is the medical document?
No medical document was given, Lordship, only the petitioner defend
So the
DW.
suit is pending before the trial court since the year 2014.
But Lordship, the delay was not because of the defendants. Our
We are not supposed
DW3
to
was.
examine that issue.
Our DWs where we have produced, Lordship, one,
We
two,
have to
three.
say
DWs.
whether the ground is justified or not. Then
Only
to
Lordship,
justify
one
your
adjourn-
ground, what document is available with you?
Only this is the Lordship, the last DW Lordship. This is the last.
No,
DW.
maybe last DW, maybe he may be the last DW, but it cannot be extended for indefinite period.
Only 5 days after another date was given, Lordship. On 7/3, my petition was allowed. And thereafter, Lordship, on 12/3, the date was fixed.
So you could have prayed before the trial court for extension of the date then on that day.
That was done, Lordship. That on 12/3, I have filed one petition, Lordship. That was rejected. Against that only I am before your Lordship. Only one date, Lordship, may be allowed, and I will adduce the evidence of DW3. He is the vital witness, Lordship, as I have purchased the suit land, and this is the independent witness who is residing near the suit land, Lordship. So only one chance may be given, Lordship. I am ready to cooperate with the trial, Lordship. DW4 is also ready, Lordship.
No, you are against the order dated 12/3/2025. You
Yes,
show me
Lordship.
how this order is arbitrary or illegal. Unless you show, I cannot interfere with.
Lordship may kindly say on 7/3, Lordship came to the court. Before that, we issued summon, Lordship, to call the DW4, Lordship. Page 33, your Lordship will find 1/2/2025. So there was no fault on the part of the petitioner to adduce DW4 belatedly, Lordship. 1/2/2025, CR is put up on strength of notification number so-and-so issued by the Honorable Guwahati High Court so-and-so. It is seen that summons issued on the official witness of defendant side have not returned yet. Since it is old pending suit, the court directs Nazir Civil Court Sribhumi to ensure the service of summons on the said official witness as early as possible. So, Lordship, there is no negligence on the part of the petitioner. On 21/2/2025, parties are represented. PO is on earned leave. Fixed 7/3/25 for DWs. So in this date also, there is no fault on the part of the petitioner, Lordship. On 7/3, he came.
Okay, we will see. We will pass the order.
Lordship may give only one day.
We'll see.
Lordship. I will adduce the
Thank you.
evidence of DW3, Lordship, is a more vital evidence, Lordship. Only this DW4 is.
Okay, we will see. We will examine the order.
Lordship, I'm deeply obliged.
Item 3 for admission. Carter Metro.
May I please?
Per the last court order, Lordship, as per the last court order, I have informed this honorable court that some development is going on and in favor of the petitioner, Lordship. Now, what instructions I have received, Lordship? Yes, department has agreed to advertise the post of the teachers. Teachers dealing with the, who is dealing with the education of the children with special needs, Lordship. And this advertisement will be done as per RCI guideline, Lordship. Because recently Supreme Court has, Honorable Apex Court has passed one judgment where it has directed all the states and the union territories to comply the judgment and comply and advertise the post of the teachers as per RCI guidelines. So accordingly, this department has decided to comply that judgment and it will be advertised, Lordship. The post. I think my learned friend, what they have
My lord,
before this honorable court has been met up, Lordship.
So now what is your pay?
Lordship, since my learned friend grievances has been met up, so your Lordship may dispose of the petition, Lordship.
Do you have the written instruction?
Yes, Lordship, I have.
Yes, Mr. Pukasa.
yes, Lordship, the post, if our challenge with regard to the post of principal and vice principal, my lord. And this is a promotional post as per RCI. The question of issuing advertisement in respect of the post of principal and vice principal does not arise. Of course, the Honorable Supreme Court has directed that my lord, all the all the teaching post, my lord, in the special schools has to be filled up as per the guidelines of the RCI. And I'm placing the judgment, my lord. Ready, Dugan? itu gitu. Pintar. Here we have put to challenge the rule, my lord, this order which regulates the, my lord, the conditions for promotion to the post of principal in special school. That rule is not in conformity with the central rules, my lord. That is the issue involved in this case, my lord. And that rule has to be done, has to be formulated as per the RCI mandate. The Honorable Supreme Court has also stick to this, my lord, point. The Honorable Supreme Court judgment, this main judgment is annexed with this writ petition, and the latest judgment, my lord, order passed in the writ petition that I have also furnished, my lord. Along with, my lord, another judgment I have given, this is passed by this honorable court in a similar circumstance in other case, my lord. In respect of vice principal, there was no B.Ed degree was essential for the higher secondary school, general higher secondary schools, my lord. As per NCT, my lord, it is required. Therefore, my lord, we have put to challenge to that, my lord, rule, and this honorable court has also passed the order, my lord, directing that the B.Ed is essential qualification for the post of vice principal. That judgment I have given, my lord. The principal ratio is that, my lord, the NCT and the RCI, whatever they provide, my lord, has to be followed by the state government, my lord. And apart from that, there was one statutory warning is given, my lord, that I have also given, my lord. Unless it is followed, it is a penal provision is also there. And the Honorable Supreme Court, my lord, has made it clear that judgment we have annexed with the writ petition. Page number 144 onwards. Relevant page 205, 207, 240, 237, and 209.
So you are challenging the rule.
Yes, Lordship.
Whether notice was issued to the advocate general.
Yes, it was done. Last occasion, your Lordship has asked this question.
Yes.
And,
Last
yes,
occasion,
yes.
no.
Last,
Last
therefore,
occasion,
my
I
lord.
appeared.
Yes.
Last occasion, no.
আপনি এখানে তার আগে তো বলেছিলেন question to. It was asked, my lord, and as such, my lord, the government advocate was Mr. S. Nath, my lord, was requested to appear, my lord. He appeared on 2 occasions, my lord.
Uh, Fair. Let Mr. Nath come.
Yes, Lordship, no problem. But the judgments I have given that we kept the record.
It will be the record.
One judgment I have also provided before.
Item 4.
Please, your lordship. Your lordship, the petitioner is aggrieved by the order dated 29th October 2022, whereby his prayer for allowing him time to file written statement against the counterclaim was rejected. What happened here, your lordship? The petitioner filed a suit before the learned court of Munsif Mingaon, Kamrup, your lordship, for declaration of right title
So,
interest.
did the other side present?
Your lordship, they heard earlier, they took time.
Pardon?
On the last date, they took time.
Okay, court master will contact him. Wait for some time.
Oblige, your lordship.
Have you seen the council today?
I haven't seen, I will try to contact him. Wait, number is there.
For bail hearing, item 5. Item 5.
CT received.
Receive, my lord.
What is the stage of investigation?
My lord, not many progress, my lord, nor it is still in the initial stage, my lord, because my lord, several accused, my lord, yet to be arrested, my lord. And my lord,
No, accused are yet to be arrested, that's all right, but whether any witnesses are examined or not?
the examine, my lord, already examined, my lord.
Examined.
And my lord, one thing,
Mr.
my lord,
Sharma, you see, the ground on which this second bail application has been
yes, man,
filed.
yes.
What is the ground? The council is absent.
Yes, man.
Let it be on another date then.
Man,
None appears for the applicant control. How about Mr. Sharma present? Sharma? D. Sharma learned additional PP along with the city clerk. I'll list the matter after 1 week.
CD will retain, man.
Till then, Mr. Sharma shall retain the city.
Number 6, matters for orders.
Your Lordship, on the last occasion, there was a query with regard to filing of a wakalatnama in this case. Now, from our record, it appears that we had filed, but it is not reflected in there. So we may be given some time to check with the registry. We have the photocopies which we had filed, but it is not there in the record, Your Lordship. 2 more wakalatnamas are there. So it may be urgent for today, Your Lordship, and we may be given time to check with the filing section and.
Okay. Mr. Pissos, learned counsel for the applicant. Press for listing the matter after a week.
After vacation.
After we vac. Okay. Here, Lord. Without any objection? No.
Lordship, any date may be fixed, Lordship.
A date may be fixed, that is.
With consent for that.
On 28.
It's a long pending case, Lordship. In fact, we have objection, but Lordship, as they want to, Lordship scrutinize the wakalatnamas. So Lordship,
Sorted.
24th, Your Lordship, if it is.
it's a Thursday, Lordship. 24.
I mean,
Oblige.
24th. good. 24th.
Item number 7.
24.
24th. Obliged.
Lordship, in this matter, Mr. Endeka is on legs.
Pardon?
Taken up, Endeka is on legs, Lordship. Maybe taken up after some time.
Okay.
We have appeared for the respondent and we have filed our wakalatnama today itself. So, Lordship, may please to allow us some time to file the reply.
Okay.
Lordship will take up after some time because matter has not been admitted, Lordship. Notice was issued. It is a regular first table, Lord.
No, they have filed their wakalatnama.
Yes, yes. There is a IA for stay.
I for?
Stay, Lordship.
Were there any execution cases filed?
Yes, yes. I think they have filed execution court.
So anyway,
Let them wait up for some time, Lordship, and take out.
Number 9.
Well, this I have for consideration of delay of 63 days. In filing appeal.
May I please, Your Honor? This matter was, the Honorable Adjudicating Authority passed a order in our favor. And that event, they have went for appeal in the Honorable Read. There also, they have delayed substantially. And the matter was condoned and ultimately heard the matter extensively. There is a concurrent finding. Moreover, there is no merit. Had there been any merit in the case, it can be condoned, no problem. Here also, there is a delay of 63 days. Over and above, they have
delay of
63 days.
63 days. Over and above, they have left the matter under defect for another 30 days. So they are acting in a very casual manner. And we are suffering being a senior citizen. It is a hard-earned money. He is suffering from 2014. And they have made a mockery of the case. There is a concurrent finding. Had there been any substantial question of law or merit in the case, then even if it can be condoned, then would have been different situation. But there is no merit in the case.
no, today we are not on the merit of the case.
Yes,
Yes, Your Honor.
Today we are only
Actual matrix is also
upon
taken
this
into consideration.
condonation of delay.
Only for 63 days for due to success delay.
And
No, no, only 63 days, my lord.
medical certificate is there. It is a routine test. This question has also raised in the appellate read court by the honorable court. That those are the routine tests. They have taken the plea of medical. There is as such no serious disease.
He is suffering of the liver cirrhosis. He
Where is the finding? There is no
He is going to be operated, my lord.
There is no finding.
Only 63 days delay, my lord. The appeal may be heard on merit thereafter, my lord. They will have the opportunity.
30 days they have left the matter under defect. Deliberately they are delaying the matter.
Already
In the
registry
lower-
notified.
in the appellate court below. Yeah. Yes. The page number 3 will explain. The judgment was given on 14. And they have given the document that is in paragraph number 3 of their IA 30/11/24. That itself shows their casualness. They have taken the matter very casually. However, I have left before the honorable court to look into the matter. Once they have delayed in the honorable court of read, they should be attentive. They must be aware. They cannot say that they are not aware. They have taken the plea that they are not aware of the delay. It's a suppression of fact. Moreover, misrepresentation of the established principle of law. He speaks about the chronic liver disease. Had there been any document?
Yes, madam, some documents are there.
Yes, these are the but he is under treatment, my lord. He is under treatment, man. They know very well, my lord. He was the partner in the area with me, my lord.
This is not the issue.
I am not disclosing this fact right now, my lord. My humble submission before your lordship is delayed only for.
Madam, there's a annexer 1. This report of Name Care Hospital shows that
Yes, sir.
suffering from liver disease.
Yes, my lord.
That is of 24. Order is passed on 4/10/24. The same plea was taken there before the Honorable Court of the Day.
Okay, we'll see. Pardon me, sir.
Indicator.
Learned counsel for the applicant and madam.
M. Kumar, Manorma.
M.
Kumar.
Gupta.
M. Kumar.
M. Kumarji.
Acha. This microphone. Learned counsel for the respondent opposite party. This application under section 5 of the limitation act is preferred by the applicant for condonation of delay of 63 days in preferring connected RERA appeal. Against the judgment and order dated 4/10/2024, passed by the learned chairperson of some real estate appellate tribunal Guwahati. In RE80 stroke Assam stroke appeal number 15/2024, by which the judgment and order dated 8/2/2024, passed by the acting chairperson real estate regulatory authority Assam. In complaint case number RERA stroke Assam stroke COM stroke 2023 stroke 47 is upheld. The learned counsel for the applicant submits that the applicant was suffering from liver disease, for which he could not file the appeal within the stipulated period. And in support of his submission, he has referred to the statement and argument made in paragraph number 3. And also medical documents enclosed with the application as Annexer 1 series. Then further submits that the delay of 61 days is a bona fide one, and therefore it is contented to condemn the same. The other hand, the learned counsel for the respondent opposite party has opposed in condemning the delay of 61 days, 63 days. It is submitted that the delay has not been properly explained. And therefore it is contended to dismiss the petition. Having heard the submission of learned counsel for both the parties, I have carefully gone through the petition and the documents present before. And also the statement and environment made in the paragraph number 3 of the application is stated that it appears that the applicant is suffering from chronic liver disease since last 2 years. And the medical documents enclosed as Annexer 1 series also supported the claim. And in view of the explanation so forthcoming for the delay, this court is of the view that the delay of 63 days is sufficiently explained, and therefore this court is inclined to condemn the same. In view of the order passed in IA number 633 of 2025, now the registrar shall register the appeal and place the same before the court as soon as practical.
May I please, Your Lord?
10 is also same.
Some date may kindly be fixed, short date. We are suffering from 2014.
It is registered.
As soon as practical.
Beg your pardon.
As soon as practical. Registry will
Sir,
do it
some
as soon
date
as
may kindly
practical.
be given, otherwise it won't be listed. Then we'll have to make a some.
Madam,
follow-up. Then it is okay.
as soon as practical.
Madam Chair. 10 is same. matter.
Same matter.
Okay.
Appeal.
Right.
Name the, have name. They have not- The name should also be reflected in the appeal.
Pardon?
Appeal, in the appeal. Our name may be reflected in the appeal.
Okay.
Much obliged.
May it please your lordship. This IA 854 is correction of address of 5.1 to 5.3, lordship.
Yes, any objection?
No objection, Your Lord.
No objection. Heard Ms. R. Chaudhary, learned counsel for the applicant and Mr.
P. Daimari.
P.
Daimari.
Doimari.
Sir.
Learned counsel for the respondent.
He's
This
appearing for
application under
respondent. One
All
four
respondents
one.
except 5.
section 151 of the Code of Civil Procedure is prepared by the applicants for correction of address of respondent number 5.1, 5.2, and 5.3. Chaudhary submits that. Why correction is necessary?
Lordship, as per office note dated 29/10/2024, unserved notice returned from 5A to 5C with an office note, lordship, insufficient address. So we have taken instruction and press addresses collected, lordship.
As per office note dated.
29/10/2024.
Okay. Ms. Chaudhary submits that. She has already taken a step upon the aforementioned respondents, but the notice issued to them returned with a report based on which office note dated 29/10/2024 was put up by the office, wherein it is stated that the address mentioned in the notices are insufficient and thereafter inspections were obtained and correct addresses were collected. And as such, there is a requirement for correction of the address of respondent number 51, 52, and 53 in the cost cycle of the RSA number 24 of 2023. The learned counsel for the respondent submits that he has no objection. In the event of allowing this interlocutory application, we are taking note of the submission of learned counsel for both the parties and also considering the office note dated 29/10/2024, this court is inclined to allow this application. The addresses of respondent number 51, 52, and 53 be corrected in the hospital of RSN number 24/2023.
Lordship, may I point out one thing? While substitution, lordship, they were numbered as 5A to 5C. So as per office note, their names were written as 5A to 5C. But in CIS system, lordship, only 5.1, 5.2, 5.3 was incorporated. So this IA has been filed saying 5.1, 5.2, 5.3. So lordship may only a note may be given that 5A to 5C are similar as 5.1 to 5.3, lordship. Normally earlier we made parties as 5A, B, C, D, lordship. Now CI system requires 5.1, 2, 3. Lordship.
The learned counsel for the applicant further submits that the registry has recorded the aforementioned respondent as 5A, 5B, and 5C.
In the record, lordship, in the hard copy.
In the record.
RSA appeal memo, lordship.
In the memo of the RSA appeal. RSA appeal. But in the CIS system, the same has been reflected as 5.1, 5.2, and 5.3. Rest shall do the needful investigation.
Lordship, I'm deeply obliged.
Obliged.
Item 7.
This is a regular first appeal matter, money appeal.
They have actually already filed an execution case, my lord. Lordship may admit the appeal and stay the execution of the decree, and we'll deposit 50%, my lord. Because in my respectful submission, my lord, the suit itself is not maintainable. But what had happened, the
What is the amount?
17 lakhs, my lord.
17.
17 lakhs 73,148. There were three, I mean, defendants in this suit, my lord. May I just give a brief background, my lord? The Numaligarh refinery, my lord, runs a school, the Delhi Public School, my lord. Now, Delhi Public School's principal entered into a contract with the respondent, my lord. His contract was terminated in 2010. He filed a suit challenging the termination, but he did not pray for compensation, my lord. Lordship knows under 14(3) of the Specific Relief Act, he cannot file a suit for specific performance of a contract which is determinable in nature. The only remedy was for compensation. No compensation was prayed for. Suit was decreed that the termination was bad. Then he wrote a letter to the DPS school that the suit has been decreed in this manner. So please terminate the contract. DPS society wrote back that the court has already held that it is not valid in the eye of law. So no further order is required to be passed. Now, taking cue from that order, my lord, he instituted the second suit, present suit, my lord, which is apparently barred under Order 2, Rule 2, my lord. Because Lordship knows under Order 2, Rule 2, whatever thing I have to claim from a defendant arising up to the same cause of action has to be
Mr.
filed in
Teka,
one single.
someone has appeared on.
Yes, my lord, someone was there, my lord.
He was there.
Because my anxiety is that my lord, they have already filed for execution. So we'll deposit 50%, my lord.
Sure.
Yes.
So no, Lordship, I have taken instruction from my senior. We have to obtain some proper instruction from our bank here. So your Lordship may please to fix after BU vacation.
So today, let us admit the appeal. You obtain instruction, thereafter we'll consider the IA.
With utmost respect, my lord, they have already filed the execution. Because after posting it after Bihu, my lord, if we get notice.
No, not BU vacation. Before, in the next week.
Next week, I don't object, my lord. Even Lordship may take it up for admission next week, my lord, no difficulty.
This matter.
This matter.
So today we admit the appeal.
My lord.
Heard Mr. Tendeka, learned counsel for the appellant, and Mr. Your good name, please?
G dash Lordship.
G dash, learned counsel for the respondent. This appeal is directed against the judgment and decree
Dated 5/11/2024.
dated 5/11/2024, passed by the learned civil judge senior division Gulagat in title suit number 2 of 2014. Certificate Rule 1 of 2014. Is to be noted here that by thinking judgment and decree dated so the learned trial court has decreed the suit. By holding that the plaintiff is entitled to recover a sum of rupees 17,73,148.50 rupees with interest at the rate of 9% per annum from the date of filing the suit till realization from the defendant number 1, 3, and 4. Peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugned judgment and decree dated so and so. Admit. Issue notice to the respondent. Returnable on
And a notice only on 2 and 3, my lord. One has already appeared.
20.
Only on 2 and 3.
Second May. Returnable, returnable after 4 weeks. Step be taken upon respondent number 2 and 3 by registered post with AD and also by usual process. From today. However, no formal notice is required to be issued since Mr. Das, learned counsel for the respondent number 1, entered appearance and received notice. However, extra requisite copy of the memo of appeal will furnished to him during the course of the day. Place the matter after 4 weeks. Adi Thalik. Mr. Endeka, learned counsel for the applicant, and Mr. Das for the respondent number 1. His interlocutory application is prepared by the applicant for staying under order 41 rule 5 of the Code of Civil Procedure for staying execution of the judgment and decree dated 5/11/2024 passed by the learned counsel passed by the learned civil judge senior division Gulagat in PS number 2 of 2014 within bracket whole 1 of 2014. The learned counsel for the respondent number 1 submits that he may be granted some time to obtain necessary instruction. Here is accordingly allowed. This is the list the matter of.
No. Before bifurcation. 11th will be very borderline, my lord. Can it be on 9th? 9th April.
Okay.
Pending item 4.
May it please your lordship. And the petitioner is aggrieved by the order dated 29/10/2020.
So are you ready to hear argue the matter?
Lordship, the brief has been misplaced, Lordship. From our chamber, Lordship.
Then what to do?
Matter may be adjourned for a day, Lordship.
Only thing is that my WS was, my prayer for allowing me to file WS was rejected. And if your lordship says, your lordship may hurt them. I'm just giving the brief of the case, your lordship. I filed a suit. I received, they filed the written statement come counterclaim on 30/7/2022. But it was not served upon us. Only on 26 September 2022, when the matter was fixed, on that day itself, we received the copy of the WS and come counterclaim, your lordship. Thereafter, the date was fixed for 29/10/2022 for written statement on the counterclaim. On that day, I filed an application for adjournment since a new set of counsel appeared on behalf of the plaintiff, your lordship. That was rejected. So my limited prayer is to allow me to file the WS against the counterclaim.
Yes, but he lost his grip, then he
As your
indicated to argue the matter.
As your lordship, please.
We'll fix a sorted.
As your lordship.
When you will be able to retrieve your brief.
Lordship, after 1 week, Lordship.
1 week.
Yes, Lord.
Heard me, sir. Your good name, please.
My B. Pushilal, your
B.
lordship.
Pushilal, learned counsel for the petitioner, and Mr.
A. Singh, Lordship, on behalf of M. Kashyap.
A. Singh, learned counsel, appearing on behalf of Mr. M. Kashyap, learned counsel for the respondent. Mr. Singh submits that he lost the brief and press for granting him 1 week time. There is accordingly allowed. Rest is the matter after 1 week.
Your lordship, can it be fixed on 9th April? 7th April. Yes, 9th April if possible. 7th. 8th.
Is there any interim order?
Yes, your lordship.
Interim order.
7th I might not be here, your lordship. Can it be on 9th?
I'm extremely sorry to trouble your lordship, my lord. In that case, my lord, notices were already issued. In my case, my lord, we have already taken steps on RN to and three. So far as 2 and 3 is concerned, my lord, lordship may await the service report. On 6th of March, we have taken steps, my lord. On the earlier occasion, notices were issued, my lord.
Wait, record.
I'm extremely sorry, my lord. My colleague has just now pointed out.
So whether appeal was admitted?
Appeal was not admitted, my lord. The lordship has now admitted the appeal.
No, it is statutory appeal.
It's a statutory appeal, my lord. It was not admitted. Notices were issued. Lordship may peruse the order of 3-3.
A letter on Mr. Deca, learned counsel for the appellant, submits that pursuant to order dated 3rd of March 2023, the appellant herein had already taken step upon respondent number 2 and 3. So await service report for respondent number 2 and 3.
Lordship may also call for the LCR.
Okay, yes. Since the appeal has already been admitted, Regis shall also call for the record to the learned trial court.
Obliged.
Your lordship, as regard item 4, it has been fixed on 9th.
Ninth.
Interim, there is an interim order.
Okay, then continue.
Obliged.
For bail hearing, item 13.
Please, your lordship. Lordship matter may be taken after some time. Senior is lapse on another.
Appeal.
Appeal.
Okay, after some time.
Item 70.
May I please, your lordship? Lordship, we tried to contact with the legal hires of the appellant.
Pardon?
Till now, we tried to contact with the legal hires of the appellant lordship, but till now no connection can be made, lordship.
My lord, this matter may be hard, my lord. It is 16 matter, my lord. For the last 6 months, my lord, they are trying to contact with the appellant. We had the information that the appellant expired. So we had informed that, but we had no proof, my lord. We could not collect any document. So it was their duty. The court directed them to collect the information and to take steps. But for the last 6 months, more than 6 months, they are not able. So my prayer is that, my lord, this matter may be hard, my lord. If they are, since they are not interested, my lord, in substituting the.
Without them, how can we hear the matter?
My lord, it is from their contact, my lord, that they are not interested to, my lord.
Lordship, we have
contact
sent
the.
letters also, lordship.
Pardon?
We have sent letters, but we have received no response, lordship, till date. Some time may be given, lordship.
Pardon?
Some time may be given, lord.
Sometime.
Otherwise, my lord, if the appellant is not interested, my lord, not responding, my lord, then the matter may be otherwise dismissed, my lord. Abatement or.
No, who will be hurt? The appellant himself is absent.
Yes, my lord. And my lord.
So if the appellant is not interested to pursue the matter, we have to dismiss it.
Yes, my lord. That is from their submission matter. It is clear that they have contacted, my lord. Then no response is there, my lord.
One last sentence.
Lordship.
Heard, Mr.
J. Medhi. J. Medhi, on behalf of Mr. I.S. Loskar.
Medhi, learned counsel, appealing on behalf of Mr.
I.S.
I.S. Loskar. Counsel for the appellant, learned counsel for the appellant, and Mr. M.J. Kadir, learned counsel for the respondent. Mr. Medhi submits that he had endeavored to contact the appellant, but did not succeed, and rest were granting him some more time.
Legal hires.
Legal hairs.
Appellate.
Legal hairs of the appellant who admittedly suffered this. but he could not succeed, and therefore it is contented to grant him some more time to contract the legal heirs of the appellant. Here is accordingly allowed, rest of the matter before vacation,
After vacation, Lordship.
after vacation.
But 2016 matters, my lord. The appeal matter may be given, my lord. My lord, appeal date may be given, my lord.
Last of it.
2016 matters, my lord. Appeal, 29 April. My lord, that may be observed, my lord, that last chance may be given, my lord. That may be observed, my lord. And that way.
It is made clear that no further chance will be given to the counsel for the appellant.
Obliged, Lordship.
Item 18.
My lord,
What are
unnecessary, my lord, virtually, they have delayed the matter. They filed a suit in appeal in 17. Virtually, their lease deed also expiring, my lord, in appeal, my lord. And they are delaying the matter, my lord. They have no
Today
right, my
also
lord.
remain absent there.
My lord,
Today also they remain absent.
absent, my lord. Virtually, my lord, no case at all, my lord. They have wrongly, my lord, treated, my lord. The trial court, my lord, rightly, my lord, passed the order that civil suit is not maintainable, my lord, under the Surface Act, my lord. Because section, my lord, 34, 35 is very clear. And 1313, my lord, section 1313 says that lease, if it's taken subsequently, my lord, that is not invalid. They are Supreme Court judgments, series of judgments, my lord. Second place. This is not a case, my lord. I think it should be dismissed, my lord. Let them come again.
None appears for the appellant on call. How about Mr. Z.N. Sayola, learned senior counsel assisted by Ms. So present for the respondent. Place the matter before vacation. 10th of April.
10th of April.
In the event of subsequent non-representation of the appellant, appropriate order shall follow. We'll dismiss it in the event of.
It come back. Let me come.
Lordship, I'm praying for some time, Lordship. Some developments are there, Lordship. Maybe taken up after vacation.
My lord, their lease is expiring, my lord, on 8th of April. My lord, I do not understand, my lord, how we can.
Lordship, it is a tendency, Lordship, even after the lease is expired, Lordship, it can be renewed also. Lord, some developments are there, let it be listed.
Developments means what kind of development?
What happened, Lordship, the tenant here in the petitioner, they are trying to shift their place of business. They are trying hard. Even they are talking with some person also. Maybe by 1st of April or 2nd of April, it can be done. That's the reason I'm praying, Lordship. Let it be listed just after the vacation.
If they shift their business, what will happen?
No,
They will vacate it.
Premises will be vacated. That's the reason.
Okay, 10th of April, my lord, your lordship is right.
10th of April, Lordship.
10th of April?
Lordship.
Okay. Later on,
Lordship.
sir, your good name, please.
My S. Chakraborty.
As Chakraborty, learned counsel for the.
Either 9th or 11th, Lordship, not 10th, Lordship. Either 9th or 11th, Lordship.
Yes.
Then, Lordship, 12 is the last day.
12 is holy.
Last day.
Then it may be on 8. It may be on 8.
Only on hearing that.
Lordship.
On 8, my lord.
On the
8.
Lordship.
Okay.
Okay.
8.
Numbers 19 and 20.
May it please your Lordship, I'm appearing on behalf of respondent number 1, Lordship. My senior is placed in court number 9. Since Panchayat matter, election matter is going on, series matter, kindly adjourn the matter for the day, Lordship.
Madam?
They could have told me yesterday, Lordship. I came for this case only.
Okay.
Ni short day, Lordship.
Miss, your good name, please?
A.B. Kayastham.
Amy Castro, learned counsel for the respondent number 1. With consent from the other side, press for listing the matter.
On 3rd Lordship, 3rd April.
3rd of April.
Third Lordship, senior is out of station. Fourth,
4th is no hearing day নহয়.
Only
3rd.
hearing day.
নহলে 10 হ'ব লাগিব।
Respondent
নহলে
number?
8
5.
Lordship 8.
Your good name, please.
Yes.
Yes.
8 Lordship.
8. Okay. 8.
Oblast Lordship.
23.
Wait, it can work. It can work. Yes.
With pleasure, Lordship. Lordship, this appeal was filed on the ground that after remand of the case to the tribunal again by the Honorable High Court, the tribunal failed to give reasons on all the issues.
Reason on?
All the issues. There is direction from the to give reasons on all the issues. Primarily, the case had come before Lordship to the Honorable High Court the first time. That the claimant had failed.
Was there any direction from this court?
Yes, Lordship.
Can we go through that order?
Yes, Lordship.
Page number?
I'll just take the Lordship. Yes, thank you. You could go to already. Judgment date 28. Lordship, it's in the year of affidavit filed by the our respondent, Lordship. I find it easier to refer to this file. Page number 30 of the record.
In IA.
I, Lordship. Open code gulo এটা।
How are you? One 149. In this IA, no order was passed. Yes.
So I'm just reading out the judgment of the Honorable High Court, the previous appeal.
Page number 13.
Page number 13.
So page number 13 is an order.
Yes,
by which this court was placed to admit the appeal.
Yes, sir. No, and this APS, same.
No, where is the direction of this court to give a finding on all the issues?
Number 1429-2023.
149/2023, filed by the opposite party, my lord, page 20.
29, number 30.
1429, IA number.
I number 149.
There is no page number 29 here.
Running page. How is the Lordship, may take up IC 1429.
Yes.
Reply filed by us, my lord.
Reply filed by.
They have referred to
I
that.
filed by us, my lord, to withdraw the 50%. In that case, my lord, we have filed reply. In the reply, we have annexed. They have not annexed. We have annexed.
It referred to the judgment in the application.
IA number 340. Okay, apart from that, do you have any other ground?
Yes, Lordship, apart from this, that the deceased was a government servant, Lordship. So age ought to have been considered as per the age recorded in the service book or some education qualification certificate. He was a the education department official, but it is taken as per postmortem report, which is grossly wrong. It is standard ELOs, not postmortem when other documents are available.
So that service book was exhibited in the tribunal.
Which one, Lordship?
This service book was exhibited.
No. It was, there's no, it should have been called for by the tribunal. In fact, there's a very clear judgment. The tribunal is not there to accept every document. Being
No, whether tribunal has called for the same.
no. In fact, he had taken the postmortem report as per postmortem report. Being a official of the education department must have had some educational qualification.
No, but whether
service
there
book-
was any pair before the tribunal that this service book has to be called for from the concerned department.
It's the duty of the tribunal, Lordship. No
Duty of
prayer
the
need to be
tribunal.
made. The tribunal, in fact, I can rely on the judgment of the Supreme Court Lordship Oriental versus Mina Burial, where it stated the tribunal being educated in law has to call for this. It's not there to just accept any document. Mina Burial judgment is very clearly stated. It's a government servant. For any thelawala, kuli, it's a different thing. Yeah, one has to accept whatever is available. But for a government servant, when there is a better evidence available, why rely on a postmortem report, which is at
No,
best
but whether that line of argument was advanced before the tribunal, that this was a service personnel.
he is claimed as a service of his entire compensation has been claimed on the basis of the fact that he is a government servant. So it need not be pleaded. I mean, that proof has to be asked for by the tribe.
And unless it is whose duty to produce the same.
Claimant he has to prove his own case.
Claimant.
It's the duty of the plaintiff or the claimant to make his case stand on his own. If he says this is the age 41, he must prove evidence, adduce evidence to prove it. Income is his burden, age is his burden. He is in personal knowledge, not in the knowledge of the other side. Lordship, I'll give your Lordship a judgment to the effect. I don't know if I have it right now, but that is here. Mina was very clearly stated. Mina Burial, MWNA. Mina Burial.
Admit card, my lord, it is 40 years. Original admit card, and age is between 41 to 45. At the time of accident, he was 40 years. Even is 71. Date of
That
birth.
must have been produced before the tribunal.
No, whether that admit card was exhibited before
Not
the
exhibited,
tribunal.
but that was not raised, that has been discussed here in the debate. Already there, my lord, it is original, just real fact.
Pardon?
This is, my lord, as dispute has come here now, my lord. So I have to, my lord, point out here, my lord, I have brought this admit card also. But admit card shows
No,
that it is.
can you sitting in appeal, we can consider that document now. This was not before the trial court,
No,
tribunal.
not, but not, my lord, that is
Then-
correct, but here what has been, my lord, mentioned by the learned member, my lord.
Hmm.
Here it is specifically mentioned 41 to 45. And that was not disputed, my lord, as it is evident from paragraph 13 of the judgment. Anyway, my lord.
Paragraph number?
13 of the judgment, my lord. Page
It
17.
need not be disputed. It has to be standard. Not sounds. It লিখা নাই তো এইবিলাক কথা।
এখানে একটু ওলোৱা নেই।
ওলোৱা নাই, দিবই লাগিব।
Yes, Mr. Goswami, what are the points? One is that age.
One is a date. The other lordship, I'll have to take a lordship to my memo of appeal lordship. To show how grave the situation, the gravity of the argument lordship. May I read out lordship? What is the judgment and award passed by the learned tribunal member without giving a reason
You
finding
come-
on
You directly come to the grounds.
grounds? I'm coming to grounds, lordship. Ground number 2. What are the judgment and award passed by the learned member without giving a reason finding on all issues as directed by the Honorable High Court, while reminding the matter back to the tribunal for passing a judgment on all issues. However, the learned member passed the judgment without any discussion on the following materials on record on the issue of rash and negligence before holding the appellant liable for compensation. First thing, number 1 point is there is no GD entry in any police station about the accident. The FIR was filed after 3 months after the accident and 2 months after the death of the husband of the claimant. The vehicle is shown to be seized by the police on 7/3/2012, but the signature of the owner is not found in the seizure list, which casts doubt on the genuineness of the seizure list and adds substance to the fact that there is collusiveness between the claimant and the police. The owner of the vehicle has filed written statement and has also given evidence categorically denying involvement of the vehicle and also employment of the driver because it is a self-driven vehicle and he had never had a driver. He also stated that his vehicle was not seized by the police. This is the main ground, Lordship. I'll read out the next para also, Lordship. What is important to be noted here that a driver who was alleged to be the driver never appeared before the Lordship. It also caused doubt whether driver, because the owner says he never had a driver. Vehicle was never enrolled. Seizure list, his signature was not there. And has filed a separate petition before this honorable court also, the owner of the vehicle, denying all these facts. For that, the learned member ought to have appreciated there is a settled legal proposition that a judicial order must be supported by reasons recorded in it. Thus, while deciding an issue, the court is bound to give reasons for its conclusion. It is a duty and obligation on the part of the court to record reasons while disposing of the case. The hallmark of the order and the access of the judicial power by judicial forum is for the forum to disclose its reasons by itself, and giving of reasons has always been insisted upon as one of the fundamentals of sound administration of justice. Delivery system to make it know that there has been proper and due application of mind to the issue before the court, and also as an essential requisite of principles of natural justice. The reason is the heartbeat of every conclusion. It introduces clarity in an order, and without the same, the order becomes lifeless. Reason substitutes subjectivity with objectivity. The absence of reasons renders an order indefensible and unsustainable, particularly when the order is subject to further challenge before a higher forum. Recording of reasons is a principle of natural justice, and every judicial order must be supported by reasons recorded in writing. It is therefore humbly submitted that the impugned judgment order dated 4/8/2020 passed by the member MSCD Hailakandi is bad in law as well as in facts of the case and is liable to be set aside. Lordship, my point is very strongly supported, corroborated by the owner of the vehicle, who is also before the Honorable Court, and filed a petition before your Lordship. Application on this same very.
Whether he has contested the case.
Yes, Lordship.
case before the-
Filed written statement and gave evidence before the tribunal. Denying all facts. The seizure list has no signature of the owner. That has to be there. When the involvement is denied. It appears to be a big fraudulent collision between the claimant and the police, Lordship. In one such case, Lordship, I had referred to, the owner of the vehicle had challenged his GA. I have given a copy of that order is also with me. This Honorable Court had referred the matter to CID, and it turned out the owner was correct. His vehicle was not involved. Lordship may allow me to refer to these two, Lordship. Huh? Lordship, this record of that particular case was, I think, has been tagged to this case, which I'm referring
Okay,
to.
we'll see.
WPC number 20. The same facts, Lordship, the owner had come before the court, denying allegations. The court ordered the CID to investigate, and it turned out it was a false case. The vehicle was not involved. Some other vehicle was implanted. It's WPC 498 of 2011. I had made this prayer before, and according to the record has been tagged to it. To this file. Record of that case, WPC 498 2011. My short submission. For the sake of interest of justice, Lordship, the owner of the vehicle may not be Lordship held liable. His vehicle is not involved. The insurance company, by virtue of being the owner, insurer of the vehicle, also should not be liable because the fraud is involved here. Or maybe it requires a very serious
Mr.
investigation by the
Goswami,
police
that,
once again. Matter
fraud-
may be referred back to police for a further investigation.
So you were pleading fraud.
Yes,
And
Lord.
fraud has to be established, has to be proved. The burden is upon you.
I'm analyzing these facts, Lordship. That there's no GD entry in this case. GD entry is equivalent to a FIR, Lordship, as per Lalita Kumari. It has said a GD is a kind of a FIR. It's the first in point of time. Even before the FIR is filed with a lot of.
The mere absence of GD entry. We
FIR
cannot
was
prove
filed after
the
3
thing.
months. That is again under a point in that Lalita Kumari's case. Supreme Court had taken note of the fact that
No,
related FIRs are
Mr.
manipulated FIRs.
Mr. Goswami, this is not a criminal proceeding.
I understand, Lordship, but basic facts.
And this
It's
is
not a
not a
criminal
trial.
proceeding.
This is only an inquiry.
Lordship, I understand that. I understand that. But Lordship, if a fraudulent angle surfaces, then that cannot be condoned, Lordship. And one can be condoned for Lordship. Let the police inquire whether this vehicle is involved. There's only one point involved. Let the police call the owner again. Or the driver. Why the driver has vanished, Lordship? Driver is not there before was not before the tribunal, Lordship. If he was actually the driver as implanted, he should have been there before the tribunal. He did not dare to face the tribunal. It's an inquiry. But even that honesty has to be there. It's a beneficial lesson for the claimant, not for the owner of the for the other persons. And driver cannot be allowed to commit a fraud. The owner cannot be allowed to commit a fraud. Here some other agencies are involved, the claimant and the police.
But that has to be established.
Or we can only take
We
cannot force the police
we are
authorities,
making
Lordship.
some averment in the appeal memo.
The police has
Not
to
sufficient.
come clean in this, Lordship. They have to give a report whether that is the correct thing. No GD, no FIR for 3 months. And
Yes,
just
so-
because one statement which is strongly denied by the owner of the vehicle, whose vehicle is supposed to have caused the accident.
Who is for the
Very, very
respondent?
strong factors, Lordship, for an investigation. No GD entry, no FIR for 3 months. And the owner says it's not my vehicle, was not involved. The seizure list does not contain my signature.
Yes, Mr. Das. You are for respondent number?
1, 1, 2, 3, madam. So, madam, just madam, I want to point out what has been stated by learned friend, my lord, regarding the one pending calling of the reports, my lord. That case has been, my lord, dismissed, my lord, regarding the CID inquiry, etc. None appears well there, my lord. Anyway, your lordship will indeed here, indeed.
Lordship, I don't, sorry. That case, Lordship, it met a very peculiar ending. What happened? I was in that case, particular Lordship. The owner, the petitioner was exonerated. Okay, your vehicle is not involved. You go and make a petition, file a petition before the tribunal with this order of the Honorable Court that my vehicle, he should be exonerated. Then, Lordship, the MBI and the police inspector, the government was directed to bring approval for their Lordship. Now, the government employees, Lordship, they have to. Now, that took some time. It was finally the case was proceeding against the MBA and the police, Lordship. I have all the orders of this case with me. Lordship may see. But what happened, Lordship, on one fine day, I was not there because I was the insurer of that vehicle, not there. The petitioner himself left the case because he was directed to go and file it before the tribunal. It was actually case against the MBA and the inspector. But unfortunately, it's a new judge who had taken found the petitioner absent, maybe even on the previous day. The case was dismissed for default. It made and the person who benefited is the MBA and the police, whose sanction had also been brought by the government for prosecution.
Yes,
So
Mr. Das.
that does not deter from the fact that originally the case was here. That's a different. It made a very peculiar ending.
Reference slip, my lord, from civil hospital Hailakandi exhibited is counter of GDNP, my lord. From the hospital reference, my lord, reference slip 1 was there, my lord, regarding the GDNP, my lord, counter of GDNP exhibited.
Page number?
I'll mark there, my lord. And next point is that, my lord, regarding, my lord, so for prima facie case, it was, my lord, seizure, my lord, police proved the case prima facie with MVI, seizure of the offending vehicle, etc. My lord, seizure of the offending vehicle.
Seizure?
Seizure of the offending vehicle, my lord. My prayer is that, my lord, so far my learned friend or has been pointed out regarding the GNDNT causing delay of, my lord, lodging the FIR, etc. There is numbers of judgment regarding the for my lord, that can be excused, my lord, because of the, my lord, mental agony, my lord, etc. My lord, fellowship. And thereafter 47, my lord, first time it was dismissed. MSc appeal was MSc case was dismissed in the learned court below, my lord. After thorough hearing, my lord, matter was remanded back to the learned court below, my lord, again. After hearing on merits, case has been decided. It was the accident of the year 2011. Date is there, my lord. Already he has expired in the year 2011 itself, my lord. And so far our involvements are there, my lord, your lordship. My lord, what has been mentioned regarding the issue of the, my lord, age of the, my lord, victim, my lord, at the time of accident. It is, my lord, prima facie, there was no such type of dispute, my lord, regarding the age. What has been learned, my lord, member has been specifically pointed out here. He is between the group of 41 and 40. He has held, my lord, 41 to 42 group, but actually it is, as it is seen, my lord, it is correctly, my lord, it is, there is a similarity in his admit card and also other papers also. my lord. Hmm? Original admit card is also. BP accident and treatment, their numbers of papers are here, medical prescriptions and.
Whether those documents were executed before the trial court or tribunal.
All are medical papers. Once. Up to 368 medical document. All are ready.
Any other point?
No, madam.
Lordship, I just want to give a rejoinder about the GD entry. The date of the GD entry may be looked into, Lordship. Because what I mean, there are two kinds of GD entries. One is when the accident occurs and the person goes to the hospital, where the postmortem is Lordship here. The GMC has also police station there. Whenever there is a postmortem report, the GD entry is made. That is not the GD entry of the accident. These are two different kind of. That GD entry is not a issue here. Issue is there whether there is a GD entry about the accident itself. GD entry about that is, I'm not on that, so it's not an issue here.
Yes, so who is for respondent number 2? Oh, sorry, 4. You are.
My lord, I am the owner of the vehicle, my lord. The fact is that my vehicle is insured, my lord. So therefore, my lord, the important cardinal question in my humble submission, my lord, why despite of that, suppose my lord, in a normal course, a vehicle is made with an accident, my vehicle is insured. Why should I go and object that my driver is not involved, my lord? Because anyway I am covered. Anyway I am covered, my lord. But here in this case, my lord, the owner of the vehicle, she appeared, she filed his written statement. She laid her evidence. And in the evidence, she categorically stated that I did not any driver. My vehicle was implanted for a wrongful gain. That is the cardinal question, my lord, which cannot be required adjudication, my lord. Not appear if my vehicle is insured, because the liability is on the insurance, not on me. That evidence lordship will find in the trial court judgment, my lord. Here, my lord, against that, they have filed an appeal. The appeal in my lord, my learned friend has already taken your lordship to that. the matter has been demanded to decide as a whole, my lord. Now, what is, my lord, the concept of that? Remanding the matter as a whole, my lord. My lord is aware that, my lord, the order 41 of the CPC dealt with all kinds of remand, my lord. Now, my lord, it starts from order 40, my lord, 3. Order 41, rule 23, order 41, rule 23A, order 41, rule 24, and order 41, rule 25.
Where is the remand order?
My lord, remand order, my lord, page 29,
Page 29, your lordship again.
my lord will find it 1429, my lord, I have pointed out. Start from page 31 and ended with the page, my lord, 32.
In IA number?
In IA number, my lord, 1429 of 2023, lordship. বুড়ি একটু আছে রে। ও, এই My lord, I can just assume this order, my lord. This is the, no, this is a judicial order. That is why, my lord. Lordship will find out, my lord. Your opinion.
Yeah, in this, isn't the IA facilities are not here.
Yes, there were only 3 issues before the tribunal.
Yes, my lord. Now, lordship will find pay after describing everything, my lord, para 18 of the said judgment, my lord, of the honorable court, my lord. First round of appeal. Lordship will see the court is remanded, the case is remanded to the tribunal for passing a fresh judgment on all issues, my lord. Now, lordship will, in context of that, my lord, may look into order 41, rule 23A. Remand in all other cases where the court from whose decree an appeal is preferred has disposed of the case, otherwise done on a preliminary point, and the decree is reversed in the appeal. Here, decree is reversed in the appeal, my lord. What is reversed in the appeal? And a retrial is considered necessary. The appellate court shall have the power, have the same power it has under Rule 23. Here, my lord, this honorable court has remanded the matter to the tribunal to decide all the issues afresh. Therefore, my lord, in my humble submission, it was incumbent upon the tribunal to decide all these issues, my lord. Now, it is to be seen now whether the tribunal, in pursuance of that order, decided all the issues or not. My lord. Now I'll take your lordship to this, my lord, the tribunal's order. That has been, my lord, annexed with the memo of appeal. Lordship will kindly. Now, lordship will kindly look into the memo of the appeal filed by the insurance company, my lord. Now, if your lordship look into page 14, my lord, then it is para 6, start with the issues.
considering the rival pleadings. My lord is got.
Yes.
My lord, the first issue, whether the accident occurred involving the Tata Nano vehicle number so and so of OP number 2 bearing the registration number yes so and so, my lord. So this is the issue. All the issues, these are the issues earlier also. This is the issues now also. So this honorable court, as per the order of this honorable, all the issues is required to be decided. Now, my lord, will see kindly how they have decided issue number 1, my lord. That my lord will find from my lord. Para 9, my lord.
Yes.
Lordship will here from the record it appears that court earlier by judgment on an order dated 13/7/2015 dismissed the claim. So claim they first they are dismissed. After discussing the evidence of 5 witnesses examined on behalf of the claimants, holding the investigating officer, including the investigating officer, holding that the Tata Nano vehicle bearing number, registration number, so and so was involved in the alleged accident and against the said judgment and order, the claimant side preferred an appeal before the Honorable High Court, and the Honorable High Court in MSC number so and so allowed the appeal, holding that the appellant side proved the case on the basis of preponderance of probability. The Honorable further of the tribunal committed a wrong in arriving at the decision, and thereafter the Honorable High Court set aside the judgment order dated 13/7/2015. In view of the above decision of the Honorable High Court, no further discussion is required in the issues. Now, my lord, whether this finding is contrary to the findings of the, my lord, the Honorable High Court, where the Honorable Court, where exercising the power under Order 41, Rule 23A, remanded the matter, that you decide all the issues afresh. And whether it is incumbent upon the tribunal to decide all the issue. Now, my lord, since this issue was not decided by in my humble my lord submission, lordship may kindly look into the judgment passed in the earlier judgment passed against which they have preferred the appeal. The claimant side preferred an appeal, my lord. That is in the trial court, my lord. The trial court judgment.
7/2015.
It is of
13/7/2015.
my lord. Judgment. My lordship may kindly appeal.
No, appeal is preferred against the judgment dated 4/8/2022.
My lord.
The earlier decision of the tribunal was set aside.
Set aside.
Then material was remanded.
Remanded.
Then is there any relevancy with this appeal?
Appeal because, my lord, the tribunal failed to discharge its duties to discuss all the issues. Because issue number 1 is relevant because other issues follows from that decision. That issue, my lord. Because the issue number 1 is that whether my vehicle was involved with the accident at all or not. And in this, and therefore, my lord, this honorable court has remanded the matter to decide all the issues, my lord. That is why I am, my lord, taking my lords to the earlier round of this. That will give some key on the, my lord, how the issues were decided, my lord.
No, we cannot go to that earlier appeal.
Then, my lord, look into the evidence. Evidence is not evaporated from the record. What evidence I submitted before the trial court, that remains. Setting aside does not mean setting aside the matter with lock, stock, and barrel.
Yes.
My evidence is there. This evidence ought to have been discussed, my lord, in this judgment also, because by virtue of the order passed by this honorable court, that you remand, you decide all these issues. What is the decision on the issue number 1? He simply endorsed the issue, whatever the observation made by this honorable court. That was not the, my lord, the order passed by this honorable court. Honorable court said yes. Preponderant probability is there, but you, in despite of that, you decide all the issues. That issue was not decided, which is a cardinal issue in this case. And more particularly, when the owner appeared before the tribunal, he laid his evidence, clearly stating that my vehicle is not involved. I never have a driver. No, I never had a driver. It is a self-driving vehicle. That is why, my lord, I am pointing out to because this evidence was discussed by the tribunal in an earlier round of litigation. The differences remains in the record.
You see, the earlier judgment of the tribunal was set aside.
Yes, but while in their judgment, evidence was discussed. Evidence is there in the trial court. The learned
No,
court.
that evidence ought to have been discussed in this appeal. No, in this judgment,
Which judgment, my lord?
the evidence already before the tribunal
Yes,
ought
Lordship.
to have been discussed in
This judgment, in this
yes,
appeal.
33 of the.
It should have been, they simply said, we need to discuss that issue. Since the honorable court has come to a prima facie that the case was proved by preponderance of evidence, we need not to go discuss these issues. But that was not there. Tribunal, this honorable case will discuss all these issues. What is the discussion on that issue, my lord? If this issue had been discussed, then the evidence laid by me would have been surfaced, would have been, my lord, come into light. And here, my lord, the driver of the vehicle, he filed a written statement. Lordship is aware, written statement nothing but a pleading. It should be proved by the evidence. He did not file any evidence. He did not make himself available for the cross-examination. What is the consequence of that? Supreme Court has settled this matter. Driver. Because our case, their case, though there, it is a, my lord, something like a match fixing between the claimant and the driver and the police. So driver, he filed a written statement, but he did not appear. He did not lay his evidence. He did not made himself on the cross-examination.
No, you cannot compel him to appear and adduce.
No, I'm not compelling. What is the consequences follows from that? The Supreme Court has discussed.
He knows very well about the consequence of the same.
Yes.
Despite he chooses not to contest
Yes,
the case,
yes.
you cannot compel him.
That also prove collusiveness, Lord.
Yeah, that's also proof.
Collusiveness.
No, that is only
When
inference.
someone, the owner has faced, so his employer has objected strongly that he was not my driver. His running away from the court merely proved that particular point. Yes, he was
Okay,
not the.
let us do one thing. We set aside this judgment.
Yes.
We remand the matter to the tribunal.
Yes.
To give a finding in respect of all the three issues.
Including issue number. Including issue number 1.
All the issues includes
Yes,
issue number 1 also.
Yes, right.
Okay.
Problem.
No, since we are remanding the matter to the tribunal, you go and establish your case before the tribunal.
Driver was not appeared in the court, and he is put and he was. And I have said that I want to hear my signature also in the record. I did. My signature is there. The report.
Tribunal decision is there, my lord. Tribunal said, my lord, opinion number 3 has not reduced in evidence. That is the driver to substantiate his claim evidence. Yes. No, তুমি পড়া এইটো প্রেসিডেন্ট পড়া এইটো পেজ নাম্বার 37 পেজ নাম্বার 37 পেজ নাম্বার 37 Police, that is a different issue, my lord. That is why it is implemented. That is why it is. And if my lord, if you still insist, I can place a judgment of the Supreme Court. Para 17 is very clear, my lord.
No,
My lord, that is why.
We are not deciding the appeal on.
Yes, my lord. Let them decide the matter.
May I please, your
Yes.
lordship, regarding item number 3. Since your lordship had summoned Mr. Dina, but I don't know whether he is available or not. But as I have discussed with my colleague, he also agrees with this notification. His only condition is, only objection is that there is an, if your lordship takes out the
instruction excluding the post of principal. So I have told my lord that there should post of principal should have to be
Should also be inserted.
inserted. Unless your lordship gives a direction for insertion, my lord, it cannot be. Because they have
Lordship may
rejected the
issue
claim.
direction that since they have already issued notification for filling up the vacant post of vice principal. So my learned friend had insisted me to insert the word principal. It's okay. Department will issue that one.
The post of principal is also lying vacant.
Yes,
Yes, yes.
then lordship may dispose of the matter instead of keeping it pending. The notification which I had produced before your lordship of 26 to 25, it is before your lordship. My learned friend also agrees. The only word he wants to insert is that the post of principal.
The post of principal, my lord, post of principal will
department will
be
act
inserted.
accordingly.
Your lordship, while allowing the retribution, inserting the word post of principal, my lord, that the impugned provisions of the executive order has to be modified. The direction may be given, my lord. That's it. I have given
The
my lord,
instructions dated 26 to 20.
orders, two judgments of I have given, my lord, already. One judgment is RCI, NCT that
In the first paragraph, lordship, the Department of Princo has already taken initiative to publish advertisement through APSC for filling vacant posts, including the post of vice principal, Institute Journal. Institute means this should be there. My learned friend is insisting that this post of vice principal should be there. Along with the vice principal, the post of principal should also be inserted. It's okay, lordship.
Whether such pair was there in the.
Yes, yes. Our prayer is to, my lord, fill up the post of principal by amending the executive order. That was our prayer. Because
now department has come with it.
as the department, for pursuant to the direction of the Honorable Supreme Court, my lord, has and in the mandates of the and as per the mandates of the RCI Act, has come to the conclusion that the post of special schools should be filled up as per the norms and prescribed procedure prescribed by the RCI. So therefore, my lord, the department is on has to, my lord, modify the existing impugned executive order to that extent only, including the incorporating the provisions of the RCI.
Once the post of principal will be advertised, lordship, everything will be clear.
Otherwise, post of principal is a promotional post, my lord, as per the executive order.
That only word your lordship may enter, that word of principal post should also be advertised.
So if the post is lying vacant, why they have not send the proposal to the APSC for filling it up?
Because the impugned rule means executive order, which prescribes, my lord, from the feeder post of CDPO to be promoted, but that is not permissible as per the RCI. RCI has prescribed certain qualification and benchmark, my lord, for the promotion to the post of principal, and that has to be followed. Because the existing executive order does not include the provisions of the RCI.
No, if it is not there, can this court issue such that?
Yes, yes, lordship has the power. Because when there is a conflict between the central laws and the state laws, and it is apparent on the face of the record, your lordship can issue directions to for a modification.
Now from the
For that purpose, just a minute. For that purpose, I have already given on judgment of this honorable court in respect of another rule of 2018, my lord. That judgment is there, whereby this honorable court has directed the department to incorporate the B.Ed degree for the post of vice principal as per the mandate of the NCT. Because this honorable court has the power. That's why that judgment I have given, my lord.
Which one?
And your lordship will find. Yes, lordship. Yes, lordship.
Where is the relevant paragraph?
11, my lord, last, my lord. In view of the above, last page, my lord. Yes, because there was a challenge of rule, it was before the division bench. And here it is before the single bench because it's an executive order. Division bench is remanded back before the single bench.
Which is the relevant paragraph?
Also last my lord, page 60, paragraph 63 onwards. In the light of the proviso to section 12A of the National Council for Teacher Education Act 1993, we are of the considered view that the definition of the term graduate teacher and postgraduate teacher as laid out by in the provisions of sub-rule 2(1) and 2(p) of the Rule 2 of
Okay,
Assam Secondary
okay.
Education Provincial Service Rules 2018.
Mr. Professor,
Lordship.
there is one meeting at 12, so 1:15.
Yes, yes.
So I have to leave. Will I resume at 2 o'clock?
Yes, Lordship. It will
Mr.
take
Das,
hardly.
Mr. Das has produced one instruction. Have you gone through it?
I have just. The
Okay.
department has already taken care of this issue.
Yes.
The advertisement will come. As the director said. Then I think it is not.
We can dispose of the petition. So Mr. Purkesto submits that the ward principal has to be incorporated along with this vice principal. Can such direction be issued?
Instruction is specifically for filling up vacant post. Vacant post. Vacant post is in plural form, including the post of vice principal of.
So principal ward is not there. Mr. Purkesto submits that if the court direct the ward principal should be incorporated there, then his pair is stands fulfilled.
The authority will be authority there. They can also make it clear. All the posts, including principal or not, because the Supreme Court guideline is clear. It says that for all in a particular
Lordship may, may I just, Lordship may keep the matter pending. Let this matter come up after BU vacation, and in the meantime, I will take that instructions which my learned friend had queried the post of principal.
That will be better.
Lordship.
Okay.
Lordship.
or
Yes.
there should not be any bar to have the advertisement include everything. Then it goes.
No, my lord.
Yes.
It has to be decided on merit first, my lord. If it is not.
Okay. As agreed by learned advocates of both the parties, recessal is the matter.
After BU.
Take a date from him.
Wait, please, your lordship. Lordship, item number 25(4) can be adjourned, lordship.
Why?
Lordship, I have not yet received a memo of appeal. My learned friend is here.
Okay. Take a date from him.
Lordship,
Take a date.
Get me.
no, that date will take care of all.
Fixed at 2 p.m. Item 27.
Lordship, in this case, I am appearing for the claimant and I have filed one IA for withdrawal of the 50%, Lordship. It was last.
The amount was deposited.
Yes, my lord, together with the.
Any objection?
My lord, we have filed our objection. My lord, in fact, on the last occasion when the matter was heard, partly it was heard, my lord, and it was contemplated that the matter will be taken up as
For final disposal,
disposal. Because amount is very less, and we also want that only we have challenged the, my lord, the finding on the negligence, my lord. Apart from that, we don't have any other ground.
In this case, two vehicles involved and one vehicle already paid entire amount, 50% of the awarded amount. And the insurance company of the other vehicle has filed this appeal, Lordship. So they are objecting that till the disposal of the appeal, the amount should not be disbursed.
No, we are not saying that, my lord. What we are, my lord, what my humble submission is, when since the LCR is also here, and my lord, the service is complete. If my lord pleases, the matter can be finally heard and disposed of. So that, my lord, ends the matter, my lord, because if the amount is taken away, then, my lord, our only ground will, my lord, not survive, my lord. Appeal will be in fact. The only limited ground is that all the findings, my lord, the pleadings were against the truck, the other insurance company. The witnesses examined, my lord, the claimant, the eyewitness, two eyewitnesses were examined, my lord. Everyone has said that it was the negligence of the truck. But only on the assumption after 6 years, the charge sheet was filed. Only on the assumption that two vehicles were involved, the charge sheet was filed against both the drivers of the vehicle. And my lord, based on that, my lord, the liability has been settled on. Well, only to that point, my lord,
So
His appeal is-
accident was in between two tracks.
My lord.
No,
Accident
one-
was in
One was a Tata Magic in which the disease was traveling,
Yes.
and the other was a truck. So
Acha.
it was pleaded
There
that
was
the
a hidden collision.
no, pleaded that the truck had come from the back, hit the Tata Magic, and because of that, the accident had happened. All the witnesses, my lord, there were two eyewitnesses examined. Both of them had said that it was negligence of the truck. But the learned tribunal came to a perverse finding, my lord, based on the charge sheet, and on the charge sheet was filed after 6 years of investigation. So, my lord, just simply since two vehicles were involved, we were saddled with the liability of 50%. My lord. All, my lord, all evidence is against the
You are for the Tata Magic.
I am for the Tata Magic in which the disease
For
was
the
traveling.
truck, Mr. Goswami for the
Mr.
truck.
Goswami appears. Charge sheet is not there. It's not there.
It's not in the record.
It's not there.
So there was something very explicit in the charge sheet.
No, I have a copy of it if you want to.
No, Lordship, there is a
I have a
court
copy of
witness. The judgment reflected that there is a court witness. He adduced evidence and he exhibited two documents, Lordship. One was report by the same court witness and one is exhibit Y. That is proved in original is the relevant page of the aforesaid Khatian containing particulars of Gauripur PS case number so and so. And from that, Lordship, the court came to a finding that when both the drivers were sent for trial, it's a contributory negligence. Lordship.
And the Lordship will also see the cross-examination. All these things are there, Lordship. Our only contention is
Lordship
that
can dispose it up.
Yes, it can be
For
heard and
that
finally
only it was
disposed of.
fixed at 2 p.m. Lordship. On
if my lord pleases, it can be heard and finally disposed of, my lord. I don't object to that. Because it's not a petty amount, meager amount, my lord, 5 lakhs.
Bigger amount.
My lord, 5 lakhs is only
5 lakhs
awarded.
are- Nowadays, 5 lakhs is not a bigger.
The accident occurred in earlier day.
And the claimant lost his son, Lordship.
2010.
I have all sympathy for the claimant, my lord. I am not.
Okay, suggested that then,
My lord.
Suggested that.
No, no, as your lordship pleases,
Today
I
your
am
lordship
ready
is
today
not
also,
taking
my
up
lord.
for disposal, Lordship.
Pardon?
Today your lordship is not taking up for disposal. Your lordship is fixing it for another day.
No, if you were not pressing the IA and pressing this appeal, you can. I have no problem. I am here to hear the matter.
Then
I am
lordship
also
could-
ready, my lord. Otherwise. In
Then
fact,
you
my
said, sir.
junior colleague had.
Sir said, okay, furnish a copy to him.
I'll give him a copy. Yes, I'll give him a copy. Yes.
Monday, Tuesday, any day.
Then a copy of charge sheet may be given to me.
Yes, yes,
also,
we'll
Lordship.
provide you also.
Please, Lordship, I have copy. Okay.
I'll also
Then,
furnish her with a copy.
if the search sheet is not available, how can you argue the matter?
Lordship, charge sheet was not exhibited. Court witnesses there, other documents already exhibited.
No, charge sheet was also exhibited as exhibit 10. It's on record. Malad, there was on record, but LCR, Malad, we did not find the copy of charge sheet.
In the judgment does not.
Yes, it mentioned. It is
No,
there.
it's not. After exhibit 6 is there.
But it's in the evidence it is recorded. Yeah, it's not in the record. We have thoroughly checked the Malad records, LCR. Malad, it's not there. Charge sheet is not there.
So if it is exhibited, why it is not there?
That's what Malad, because I found it very strange. But my lord will see. He,
Judgment reflects lordship only exhibit 1 to 6. Maybe it was later on exhibited. So maybe it is on the later portion of the 10.
My lord may come, if my lord pleases, if the main appeal is taken up and the copy, my lord, a copy of judgment, my lord, internal page 6. Copy दी थी बताइए 35 कॉपी आते हैं No, we have checked, my lord, it's not there. Exhibit 10 is not, exhibit X is not there. My lord may kindly come to page 12, my lord. Internal page 6 of the judgment, my lord, in the memo of appeal. Last paragraph.
Page number 12.
Page number 12, running page 12, my lord, last paragraph. Now it is evident.
Yes.
Now it is evident from the evidence of CW1 that the charge sheet of the case followed the investigation
that had been initiated on the FIR laws following the accident. The charge sheet as Exhibit X proved by CW1 had been filed against one Gora Singh and so and so. Right? So that was exhibited, but it's not found in the record. I have a copy of it, otherwise I can provide one.
No, Lordship, Exhibit X and Y is available in the record.
No, I did not find that.
Yes, yes. it is
Exhibit
in
X1 is
X,
there.
page 2. Yeah, Exhibit X is page, Lordship. Page 73, Lordship, and above that Exhibit X is there. That Exhibit X is the report by the CW1.
So that cannot be a charge sheet. No, it is recorded, it's a charge sheet. I have a copy of the charge sheet, my lord, with me.
Exhibit X is a different.
Yes, it is a report, simply report. An
Yes,
exhibit, it's recorded that it's a charge sheet.
No,
And I am having a certified copy of the charge sheet, my lord. If Lordship pleases, I can provide, I can give.
No, no,
copies to both of them.
CW1 was called for educing evidence. He educed his evidence, court witness. He exhibited one X document that is a report prepared by the CW1 on the basis of all documents of that police station case, Lordship. Your Lordship will find Exhibit Y, page 73, LCR page 73. There it is mentioned that 2 persons were sent up for trial, 2 drivers, Lordship. One is Ghora Singh and one is Alimuddin Sheikh, or like Ghora Singh, and one is Abdul Alimur Sheikh. So on the basis of these documents, tribunal held that there is a contributory negligence, as both the drivers were sent up for trial, Lordship.
That cannot be, my lord. Not at all. He has admitted that the charge sheet was filed on assumption because 2 vehicles were involved. So as such, 50-50 liability has been settled. Well, anyways, my lord, we give you a copy of charge sheet to both the parties. If my lord pleases, it can be heard today also. I am ready. Otherwise, my lord, if Mr. Goswami has some thing to say. Otherwise, all evidence, all pleadings are against the truck. I am just dragged, my lord, because I am the one of the vehicle involved in this. And because of that, I have been settled with the liability. Truck had come from behind it had hit the my Tata Magic. My negligence was not there. Absolutely a perverse finding, my lord.
Next week.
Says I'll see the other papers correlate because what it says in the period, the first part is the narration of the man. What is the my nephew? Next line onward it says, in the period of investigation and after visiting the place of occurrence, a rough trace map was drawn and information was collected regarding the place of occurrence. After investigation, charge sheet was filed against the driver of the opening vehicle bearing both the vehicles. I have submitted that. Both the drivers. So I need to correlate with the documents whatever Sudhir was saying, and then
This 3rd of April, Thursday.
Yes, Lordship. Yes, Lordship.
Thursday.
I'm
Okay. As agreed by learned advocates of both the parties, registers and list the matter on 3rd of April. And in the meantime, Mr. Batra, learned counsel for the respondent number.
No,
My lord, I am the
Lordship,
appellant.
Oh, yeah,
I'm the-
learned counsel for the appellant shall furnish a copy of the search sheet, which is available with him to the learned counsel for the respondent number. Iwapa,
I'm for Lordship.
number 1.
I'm for 1, Lordship.
respondent number 1 and 2.
He's for 2, my lord.
Respondent
National
number 1
insurance
and
is
2.
2.
Okay.
By way of an additional affidavit, they can bring for the court
And
also.
further, Mr. Batra
No, that will make it
shall bring on record the additional affidavit, the search sheet by filing an additional affidavit. One line.
Lordship.
As your lordship.
Lordship, can it be fixed at 2 p.m. for final disposal, Lordship? Otherwise, it will again come in order columns, Lordship, as my IA is pending.
And it should be listed as hearing.
No, orders होता है वो for final disposal ready है
Okay, recess will list the matter at 2 p.m.
for final disposal, Lordship.
No, final disposal will not record it. We'll try.
Lordship.
And my lord, on that day, my learned junior friend had, my lord, prepared this case. So I'll
Yes, anyone
see
can
few
argue.
of my-
Okay, no problem.
She would like to, my lord, argue this case. Oblige.
Obliged, Lordship.
Oblige. Pending item 13.
Let the matter maybe start.
Pardon?
Worship matter maybe take care.
Respondents are not there.
Okay, let me call the response.
Item 28.
Yes.
Pratik, in this case, the vehicle insured us was a stationary vehicle.
Pardon?
The vehicle insured us was a stationary vehicle. And the deceased person was coming. He ended up, this is voluntary went under the stationary truck. And the accident took place. Because he hammered the jack. There, but the accident took place and he died.
Hammered the jack.
Jack, which was implemented with the truck because the truck was in the some condition logic.
Truck was in a stationary position.
Yes.
Yes. Thereafter?
Thereby, the deceased who was a forest guard was coming, and the mechanic was there. They were repairing the truck, but he voluntarily went to the truck and hammered the jack. Thereafter, the accident took
Where
place.
the truck was?
In
On the
side-
road.
In the side of the road.
Side of the road.
That's it. So we examined full witness.
Trial court has ignored it.
We examined owner of the vehicle, we examined driver of the vehicle. Two mechanic was examined.
No, that's all right. Can it be said that the accident has not arisen from the use of the vehicle?
Yes, that's it.
Why?
That's it. The truck was a stationary truck. And
No,
there was
have you
plain-
aware of that decision of the Supreme Court in the case of?
plain petition was filed under section 166. of the
Yes.
NBA, not under 163.
Not necessary.
So in this case, race and negligent driving is required to be proved.
Recent negligence, no. You know about the case where the one oil tanker met with an accident. Some people were collecting the oil. And thereafter, there was a fire.
That is in different context, Lordship.
How?
That is in different context.
How?
In this case, Lordship,
No, their Supreme Court says that it is arisen out of the use of the vehicle. Why the same principle will not be applicable in your case?
Lordship, I am going to the judgment, Lordship. Lordship, case number 15, Lordship.
Page number 15 of your memo of appeal.
Lordship.
Yes.
Case of the claimant is that on 5/3/2009 at about 3:45 p.m., when her husband Vikas Diti Lokar since this was returning from the Forest Department office at Saridwar and proceeding toward Balipara on foot, the offending truck being driven in a rash and negligent manner knocked her husband, resulting to his instantaneous death. The claimant has stated that her husband was 40 years of age and was a forest guard in the Department of Forest and Environment, Government of Assam, and earning 10,000 per month. The opposite party number 1 and opposite party number 2, other owner and driver of the truck, filed their written statement denying negligence on the part of opposite party number 2. The opposite party number 1 and opposite party number 2 have stated that on 5/3/2009 at about 3 p.m., The said truck, which was loaded with stone and proceeding towards Balipara, broke down near Mansiri River. The opposite party number 2 immediately informed the opposite party number 1 about the same, and the opposite party number 1 brought one mechanic to repair the truck. At about 3:45 p.m., when the truck was being repaired by the mechanic by keeping the truck standing on Z, the claimant husband came on foot and seeing the broken truck, he stopped. When the claimant husband saw that the mechanic was unsuccessful in removing a broken part of the truck, he voluntarily slipped below the truck and hit the bottom part with a hammer which was lying there. The truck being loaded with stone, the jack slipped and the truck fell upon the claimant's husband, resulting in his instant death. It has been stated that the opposite party
Yes,
number.
you find out that decision of the Supreme Court,
That's it.
which I am referring to.
My lord, this is the judge.
Yes.
My lord, here, my lord, there is a collision between the oil tanker and one another vehicle, my lord. And thereafter the oil filtrate and my lord, some persons were carrying on the then my lord, there is an explosion. And in that explosion, my lord, some persons died, some were injured. In this statement, Lordship has rightly pointed out that, my lord, whether it is during the use of the vehicle or not, that is the issue involved. Lordship, paragraph
Relevant paragraph?
Paragraph 34 to 37, my lord.
34 to 37. So let us do one thing. You, Mr. Bhatt, you go through this judgment, and thereafter you submit before the court. Where is your case? You have extra copy?
Yes.
Understood. Heard Mr. Bhatt, learned counsel for the appellant, and Mr. Gupta for the respondent number.
One, my lord.
One. And you?
He is with me.
What? Okay. Third in part, SSL is the matter 24th of April. 24th of April. In the meantime, Mr. Gupta, learned counsel for the respondent, shall furnish a copy of the decision of Honorable Supreme Court in the case of Shivaji Doyano Patil and another versus Vatsala Uttam More, reported in 1991 PSSA 35530. So as to enable Mr. Bhatt to go for the same.
Can it be possible to take up before vacation, my lord? If
Lot
possible.
of matter.
Okay.
29.
But I'm for the appellant. Claimants counsel, I don't find. My learned senior friend is, of course, for the my lord, Oriental Insurance Company, National Insurance Company. The Defend respond number 1. But Mr. Agarwal, I think it's like for the claimant. Is my lord,
Agarwal is not present.
not present today.
What to do?
In fact, what I find is that actually we had filed this case because we did not introduce any evidence with regard to cover note, because our case was that the cover note which was relied upon as to show that it was a policy. In fact, that practice had expired 10 years prior to this case was filed. That we could not bring on record because of the fact that the counsel was appearing the case did not inform the insurance company. That is the ground of appeal. Now, what I thought was actually today I checked up the records. I found that there's one application was filed by us under Order 41 Rule 27 for reducing additional documents, bringing additional documents. That I thought, since a copy was here in the file, actually it was the case dealt by Advocate Amlan Datta, who is no more. So that file was handed over to me. So I thought this application was on record, but today I checked up the records, I didn't find that application. So perhaps I would also like to file this application in the meanwhile. So perhaps since the claimant is also not there, let it be ensured. In the meanwhile, let me file this application. Otherwise, I don't have any case at all. Because without these documents, I have got nothing to argue really.
Heard Mr. M. Dotto, learned counsel for the appellant, and Mr. Usami for the respondent number.
I'm for the appellant, my lord. My learned friend is for respondent number, my lord.
Respondent number 2.
2, my lord.
None appears for the respondent number 1. Raises and leaves the matter on 29th of April.
My lord, my lord. Very much.
May it please the lordship.
Yes.
Lord, this is an appeal, my lord. Statutory appeal against conviction under section 22C NDPS Act, and sentence is for a period of 10 years, my lord. There are 2 applicants, my lord. The applicant number 1 was suffering from severe, my lord, TB, my lord. So that is why, my lord, one report was called for from the superintendent of jail Dhuburi, my lord. That report perhaps is there, my lord.
It is in record, my lord.
So what is the ground?
The ground is that, my lord, first of all, my lord, the seizure. Seizure, my lord, the witnesses, my lord, who were relied by the prosecution, my lord, they did not prove the seizure. They did not prove the seizure, my lord. May I submit on merit of the case, my lord?
Yes.
Then my lord will kindly see the FIR, my lord.
No, entire, you are not required to go to the entire matter.
Yes.
What are the grounds? Simply you tell me.
My lord, the grounds, my lord, primarily is that, my lord, the prosecution's case is that, my lord, around 24 bottles of cough syrup were allegedly recovered from the residence of the 2 applicants, my lord. In the presence of 2 witnesses. These 2 witnesses, my lord, were examined as PW1, PW1 Yadul Haq and PW3 Muzammil Haq. None of them claim to have actually seen the seizure. So this is the position regarding the seizure. Now, my lord, the law is this, my lord. If your lordship will see 52A of the NDPS Act. 52A, my lord, of the NDPS Act is regarding, my lord, disposal of narcotics, my lord. If huge amount of contraband is recovered, then the 52A says that you draw some samples. Some samples are to be kept as for primary evidence. Some samples are to be sent to the FSL. This and the remaining should be disposed of. Now, this primary sample should be produced in the trial as material exhibits, my lord, because the entire case is based on seizure of contraband. So, if this contraband is not produced before the court, my lord, then the entire case goes. On that regard, my lord, I will place some judgments, my lord.
No, there was a recent judgment of Supreme Court.
Kasif, my lord.
Non-compliance of
Kasif, my lord, that is what. In that judgment, it is said that compliance of 52A is not mandatory.
Mandatory,
It
yes.
is not mandatory, but the seizure will have, or the contraband, the physical evidence will have to be produced, will have to be proved otherwise. 52 is not mandatory, but the primary sample, say for example, my lord, no samples were drawn. No samples were drawn as per 52A. Then other way also, my lord, the prosecution will have to produce the original contraband before the court. If that contraband is itself not produced as material exhibit, my lord, then how the court will come to a finding that yes, this contraband was actually seized from the accused. So that in that context, my lord, the Supreme Court, my lord, says in this recent judgment of Bharat Ambale, my lord, I'll just read it out. That mere non-compliance of the procedure under section 52A or standing orders thereunder will not be fatal to the trial unless there are discrepancies in the physical evidence. So,
And what is the case?
that is Bharat Ambale.
Bharat?
Bharat Ambale. This judgment relied on that Kasif judgment, madam. So, my submission is that, my lord, in this case, my lord, not only the actual contraband was produced, but also the samples that were drawn were also not produced as material exhibits, man.
Pardon?
In this case, my lord, not only the actual contraband was exhibited as material exhibit, my lord, but also the samples which were drawn as primary samples under 52A, that were also not produced as material exhibit. Now, my lord will kindly see the judgment in Jitendra, my lord. I have placed, my lord. Para number 6.
Which judgment?
Jitendra, my lord. Jitendra and another versus State of MP. Para number 6, my lord. Check third page. Bottom paragraph.
Para number
6, my lord. May I read, my lord? In our view, the view taken by the High Court is unsustainable. In the trial, it was necessary for the prosecution to establish by cogent evidence that the alleged quantities of charas and ganja were seized from the possession of the accused. The best evidence would have been the seized materials which ought to have been produced during the trial and marked as material objects. There is no explanation for this failure to produce them. Mere oral evidence as to their features and production of Panchanama does not discharge the heavy burden which lies on the prosecution, particularly where the offense is punishable with a stringent sentence as under the NDPS Act. In this case, we notice that the Panchas have turned hostile. So the Panchanama is nothing but a document written.
Mr. Das, this decision is of 2003.
Yes.
And thereafter, there's another decision of Supreme Court is there.
Yes.
Perhaps it is Mohanlal decision.
No, Mohanlal is with regard to 52A, my lord.
Pardon?
52A, my lord, Mohanlal. Their judgment is there. I have placed, my lord. Sahiram judgment. Sahiram versus State of Rajasthan. That also I have placed.
No, another judgment is there regarding destruction of this seized contraband.
Yes.
So, if they have destroyed the contrabands,
Yes. Then they ought to have produced the primary sample, which they have drawn as per 52A. That was also not exhibited in this case.
What is the evidence of the IO? Let us see.
Yes. My lord,
PW 9.
PW
9 now.
PW, my lord, 10. All the exhibits are in the next page, madam.
PW 10.
PW 10, Baharul Islam.
Yes.
On 13/7/2022, I was posted at Bazar TOP under Dhuburi PS. On that day, the OC of Dhuburi PS, namely Inspector Parthopratim Gogoi, endorsed an FIR to me for investigation in connection with the incident case. I recorded statement of the informant as well as other witnesses. I visited the place of occurrence, prepared the sketch map of the place of occurrence, and also forwarded the accused persons and produced before the magistrate. I prepared the inventory and list of samples. I also communicated to the superior authority in writing as per under section 57 of the NDPS Act. I also took the initiative to send the suspected contrabands to the FSL to the office of the Superintendent of Police Dhubri. I received the report from the FSL and accordingly, I made the entry in my case diary. Finally, I filed a charge sheet against the accused person, namely Gulzar Ahmed and Ghafuruddin under section 22C 25 of the NDPS Act. Exhibit P4/P10 is the sketch map. Exhibit P15, P10 is the compliance report under section 57. Exhibit P16, P10 is the arrest memo. P17, P10 is the NNR arrest memo. P18, P10 is the inventory. P19, P10 is the list of samples. P20, P10 is the charge sheet. P21, P10 is the formal FIR. So these are the exhibits. The actual contraband was not even exhibited as material exhibit, my lord, in this case. And that was what has been, my lord, category laid down by the Supreme Court in several judgments, my lord. That I have placed, my lord. That first was the Jitendra Singh's judgment, my lord. Jitendra and another versus State of MP. That which I have placed, my lord. That judgment was relied in another judgment, my lord, in 2013. Para number 10.
What is material exhibit 1?
It is shown as nil.
Hmm?
It is shown as nil, my lord.
One MO
MO1.
MO1. Description nil.
Description is shown as nil.
MO1 is there.
Yes. But none of the witnesses have, my lord, exhibited any such exhibit, my lord.
Exhibit. Mr. Sharma,
My lord,
have you gone through the record?
my lord, I need some time, my lord. Next week, my lord, immediate, my lord.
The person is suffering from.
Yes, my lord,
tuberculosis.
my lord, as it is, my lord, argued on merit, my lord. So, my lord, I have, my lord, taken point of some note, some, my lord, judgment, my lord. So I have to.
My lord, if the IA is disposed of, my lord, and my lord, the date is fixed for hearing, my lord, after Bihu, my lord.
For IA, my lord, is.
Because the person is very sick, my lord.
Sick, regarding sickness, my lord, that is medical report is there, my lord.
I have not seen any material
My lord,
exhibit here.
probably, my lord, the Malkhana register perhaps was exhibited as material exhibit, my lord, by the CW1. That only.
Malkhana register cannot be material object.
Yes.
Material object is the case property.
Yes, otherwise, my lord, there is no material exhibits, my lord, exhibited by any witness.
So, Mr. Verma,
My lord,
person is sick,
my lord.
suffering from tuberculosis. Medical report is there. You come prepared on next Tuesday.
My lord.
Tuesday.
But can the IAB dispose of, my lord?
We will finally hear the matter on next Tuesday.
Yes.
Because on the other day, you have prayed that the matter may be hard to gather and
Yes, yes, yes.
Tuesday means 1st of April. COVID kiman ase? I think kiman man. Okay. I will fix it as item number 1. Tuesday. You come prepared. Mr. Sharma,
My lord.
there shall not be any adjournment.
My lord, my lord.
But my submission will be primarily on this matter, that nothing was exhibited. The contraband was not exhibited as material exhibit, which was required on merit.
No, you have to argue on that day.
My lord. My lord.
Mr. Sharma, you please go through these decisions which he has relied on.
Yes, my lord. I have noted down, my lord. রেকর্ড গুছি যাব নেকি তো এটা ফার্স্ট আইটেম হল না
Heard Mr. S. Das, learned counsel for the appellant, and also heard Mr. P. Sharma, learned additional PP for the state respondent. This IA, along with criminal appeal number 69 of 2024, be listed as top of the list item in the on 1st of April.
My lord, may prayer, my lord. As my lord, 3 days, my lord, holidays. My lord, kindly fix at 2, my lord, on 1st of April, my lord.
Why?
I have to go to my lord. I will get the time, my lord, because my lord, if I
Then can it be on Wednesday?
it will go to the my lord bench today.
Wednesday or Thursday, then, my lord, as top of the list.
Thursday.
So that will not be any problem, my lord.
Okay, Thursday then.
My lord. Three, no?